those are items where either the applicant or the staff has requested a continuance for any number of reasons, and it's generally been our policy to allow for continuances where they are reasonably requested. We have consent items. Those items are items where we're going to hear them today, but they have not been questioned by any member of the staff or any member of the public. So those items are on consent. Anything that is on consent, we'll read the title to the item, and if it's something that you want to pull or have heard today, just raise your hand and we'll pull it for discussion, which will go to the regular items. And anything that's on the regular items will be fully vetted today and discussed by the applicant and anybody in the audience that has questions about it. Applicants will have 5 minutes to make their presentation, and the questioners will have 3 minutes to ask questions and state their concerns, followed by a return by the applicant to respond to any questions or concerns. Has there been any request for additional time?
There has not, Mr. Chair.
Okay.
Actually, there was. Ms. Wilhite requested additional time. It was granted. For Denton.
Okay, I apologize, Mr. Chair. Denton Ave did have additional time.
Okay. All right. So if there has been additional time requested, at least 24 hours prior to this meeting for extra time, such extra time may be granted, which we have granted one request for time, for extra time. As a personal note, please, if you're here today, please keep your phones in silent position so that they won't disturb anybody that may be talking or making the presentation. And before we start, is there anyone here that's here to speak on an item that is not on today's agenda?
Mr. Chair, we do have one individual signed up for general public comment. It's Mr. Logan O'Leary.
Okay, Mr. O'Leary, would you come forward, please? We need you to state your full name and your address.
Mr. Chair, do you want to do the swearing?
Yes, we'll swear everybody in right now. So anybody who intends to give testimony today, just stand and raise your right hand and be sworn.
Do you swear or affirm the testimony you're about to give is the truth, so help you God?
I do.
Okay.
All right. Hi, everyone. My name is Logan O'Leary. I'm from 12309 Eagle Chase Way, and today I will be talking in a general sense about the development in Pasco County. I moved here 12 years ago, and since then I've seen a rampant amount of development and excavation in my community. I actually got to witness it firsthand right in front of my house as it was being built. Back then I was young and I really had no idea what was going on, and I didn't really question too much about it. But today I see the unfortunate circumstances that have unfolded in front of me. So recently I witnessed the development on Little Road on my way here. I saw them burning trees and disposing of every living thing that used to live there. I cannot personally condone such unsustainable practices, and I'm speaking to all of you in hopes that maybe there can be change that comes about to make it so when we build and we take this habitat from these animals, that maybe we do so in a way that isn't so invasive, isn't so destructive. As concerning the new developments on the agenda, I have to disagree with the new hotel and the new housing. I think that we have enough traffic here. I think that everyone...
You have to speak to the microphone. Thank you.
think
You
that,
just have to get it on tape.
yes, sir. I think that everyone has seen our beautiful county turn into somewhat of a concrete jungle. And that is not the place that I want to live, and it's not the way I want to raise my kids. So that'll be all. I just hope that when developing and planning for developing happens, that maybe we have more jobs for people who are looking to protect the environments and help Pasco from being poisoned. In a lot of water bodies surrounding my home, I've seen these neon blue and green chemicals spraying and leaving residue among the ponds where, of course, there are animals. And I think that we need to focus more on areas such as that instead of trying to build more and bring more people here. Make our place better. Thank you.
All right, thank you very much. I appreciate your coming.
Good afternoon, Planning Commission members. Gianna German, Planning Development and Economic Growth. First item on the agenda is item PC3. It's PDE 267909, a zoning amendment in the name of R&R Property Investments, LLC, and R&R Property Shady Hills. It's a rezoning request from AR Agricultural Residential District to a C2 General Commercial District located in northwest Pasco County, approximately 784 feet north of the intersection of Shady Hills Road and Floralton Drive, containing approximately 1 acre. This item now has individuals signed up to speak, and we ask that the item be pulled to the regular agenda. However, I would just like to clarify for housekeeping and for audience members that would like to participate today, that item PC6 is Denton Avenue, and this item is unrelated to that item.
All right, so you asked for a PC3 to be pulled then?
Yes, sir. There are now individuals who would like to speak on the item.
Okay. Is the applicant present? Okay, and how many people are here to speak on that one? Raise your hand. Okay. All right,
The last item that we have on consent is PC4. It's PDE 262111. It's a variance request in the name of FAM Residence Screen Enclosure. It's a variance to reduce the requirement that structures not to be located within 15 feet from the mean high water line to be reduced from 15 to 5 feet, located within an R4 high density residential district as required by the LDC section 530.13 supplemental regulations waterfront property and by LDC section 1001 4A docks and seawalls visibility located in southwest Pasco County, approximately 784 feet north of the intersection of that is not correct, approximately 1.2 miles west of US 19, containing approximately 0.18 acres. And this item now has individuals who signed up to speak as well, and we request that it be pulled from the consent agenda.
okay. And how many people are here to speak on this one? Okay, is the applicant present? Okay. So item PC3, PC4 will be moved to the regular agenda,
Yes, Mr. Chair.
okay? And then everything else is on regular, right? Okay.
Mr. Chair, would you like to hear item PC 3 and 4 first, or would you like to move to the regular agenda?
Let's go ahead and do PC 3 and 4.
Okay.
All right. You're the applicant? I'm sorry. All right. Okay, go ahead.
Good afternoon, Planning Commission. Kayla Yu with Planning Services. PDE 26-7909 is a rezoning request to change from the AR Agricultural District to the C2 General Commercial District in the name of R&R Property Investments LLC. The future land use is ROR in the comp plan, and the applicant is requesting to develop 1 acre consisting of a small portion of the entire parcel for the use of a contractor's office and storage in conformance with Section 526 of the Land Development Code Standards for Development. The subject site is located on the east side of Shady Hills Road and approximately 784 feet north of the intersection of Shady Hills Road and Floralton Drive. It is located within the North Market area. This is a context view of our map. As you can see, the subject property is the small portion highlighted in red. This is an aerial view of the map. Right there, you can see the small portion of the entire parcel. Right here, once again, you can see the entire parcel. And the highlighted in red is a small portion. The surrounding future land use to the north is ROR. To the east and the south is COM. To the west, there is both COM and Res 1. The surrounding zoning to the north is C2. To the east and to the south is AR. And to the west, there is both C2 and AR. The subject property is subject to a natural gas easement. However, staff has already met with a representative for a site visit and confirmed that the proposed zoning will not affect the transmission line. Access to the property is from Shady Hills Road, a county-maintained collector road. There are currently no conceptual or planned trails for Shady Hills Road, and the applicant has volunteered to record a deed restriction. This is coming with recommendation for approval of the zoning request to the Board of County Commissioners, and I'll stand by for any questions.
All right, do we have any questions for staff?
Is there any type of conceptual site plan that's been submitted?
There was a survey that they had submitted with the application.
But nothing showing how they would intend to develop property?
No, not as far as I'm aware of.
And they would still be restricted from building, excuse me, on this gas easement?
Correct, sir.
Okay.
Lynn, did you have a question?
I don't vote on this item unless there's a tie, but I just was wondering if the applicant had some sort of, I don't think we had pre-application meeting, but a preliminary meeting for site plan discussion. I'm only asking this because it is an oddly shaped parcel, and once you start factoring in setbacks and stuff like that, it may make it more difficult to develop. So I was wondering if he was thinking of, would he be subdividing that 1 acre off and having on its own, or how those setbacks would be, might be addressed? Not that it, I mean, that is a site development review kind of question. I don't know if he's thought of that far through. Okay.
That was the reason for my question.
Yeah, I just want to make sure the applicant is aware that once he gets to site plan review, that there might be constraints that might limit his potential.
Thank you. Amy Toll, Planning Development and Economic Growth. So the applicant is available to answer that if necessary.
All right. Very good. Any other questions for staff? Okay, if not, is the applicant present?
Yes, the applicant is present.
Okay.
Jim O'Brien representing the applicant.
Would you like to make a presentation, or do you want to wait for comments?
Excuse me?
Yes, if you wanted to make a presentation.
Yeah. Do you want to make a presentation? That's what I'm asking.
No, the applicant is aware that there will be setbacks on that 1 acre parcel. And the building that they're going to propose to build there will fit within that 1 acre parcel, including the setbacks.
Okay.
Sorry, I don't think you answered part of my question. Do you plan on subdividing that 1 acre section off?
If we need to separate that 1 acre off, we will separate that off. It just depends on how the building lays out on the parcel once the engineer gets engaged.
Okay, thank you.
You're welcome.
Quickly, Mr. O'Brien, are you just acting as an agent for the owner, or are you an attorney?
Yes, I'm acting as the agent for the owner,
You're not an attorney?
not an attorney.
Okay.
Okay. All right. Now, so is there anybody here to speak? With
Mr.
questions?
Chair, the first individual I have signed up for this item is a Mr. Martin Dolabach.
Okay. Mr. Dolabach.
If it's on this one here, that's not what I meant to sign up for. It should have been one for Denton.
Mr. Chair, I'm just going to open it up to the public if it's okay for this one, because I think a few individuals may have accidentally signed up for the wrong item.
Oh, okay.
All right. So let me see a show of hands. Who's here to speak on this item? Okay, and you've both been sworn?
Yes, sir.
Okay, if you please come at one at a time up and give your name and address.
Normally I let ladies go first, but she said she wants me to go.
And you gotta listen to her.
Thomas Salato, 18235 Floralton Drive. That's 34610. This is it. I have some pictures. Am I allowed to give those to you? I have extra copies.
Move to receive and file?
Second.
We have a motion and a second. All in favor? Signify by saying aye.
Aye.
Opposed, like sign.
Thank you, Board, for allowing me to speak. I'm opposed to this parcel.
Your full name, I'm sorry, and your address.
I thought I did. I apologize.
I just want to make sure she's.
Tom, you want me to wait?
No.
Oh, go ahead.
All right, Thomas Salato, 18235 Floralton Drive. That's in Spring Hill, Florida, 34610.
Okay, thank you.
Yes, sir. Once again, members of the board, thank you for the opportunity. I'm here and I'm opposed to this parcel being rezoned. Before you, I have my document, which I'm just gonna highlight some bullet points of, number one, we have a 2-lane road there, Shady Hills Road. Much increased vehicle flow has already seen exponentially for the last 5 years. Lots of safety concerns. There's a school within 300 yards. There's 4 schools on that road. The request is not consistent with Pasco County's comprehensive plan. There's policies governing the rural and agricultural future land use. Those areas are intended to preserve low-density residential and agricultural usage. We want to protect the rural character. C2 often will allow high-intensity commercial operations, extended hours, significant traffic growth, and outdoor commercial activity. I think this would undermine the expectation and negatively impact our affected properties, noise levels, traffic patterns, and the community character. This parcel, I live there right on the backside, as I told you by my address. It's been used commercially. There's some question marks there that I think the board should ask. Which the photos I provided, and that's where the point I want to get to, so I want to use my last minute to talk about that. Picture 2 is the entrance of the parcel, and then picture 3 is the left side of that entrance. And then picture 5 is the deep use of that parcel, which right now has cinder blocks, pavers, some pallets, and then picture 7 is a zoomed-in view. You'll see these portables being stored, and then a dumpster to the left there, an old dumpster. So for the last couple of years, I don't know why, but that's been the means of egress for storing these portables on, I believe that's on this adjacent property. So I'm not sure what's been going on there. It was supposed to be used for agricultural. It's not been used that way. I'm presenting a lot of questions to the board here. I think we have some zoning violations already on this parcel, but it's up to you to decide. You guys are the experts. Thank you, gentlemen.
All right, thank you very much. Yes, sir. Any questions? Wait, excuse me, I just want to let everybody know before we get deeper into this. We don't allow any clapping or hurraying or anything like that. We just want to be respectful, give everybody a chance to speak so that we can be heard and we can carefully consider the decision. So thank you. Appreciate your enthusiasm, but we want to just keep moving on. Okay? So I think you raised your hand?
Yes.
Thank you very much.
Good afternoon. My name is Danelle Curl, and I live at 16114 Heron Hills Drive. I live right across the street from Tom, so this property is very close to my property. So members of the board, I'm here today to oppose the rezoning of 18442 Shady Hills Road from AR to commercial. This change would directly negatively impact surrounding community, our safety, our environment, and the long-term livability of this area. The rezoning threatens the character and stability of our community. Residents in this area chose AR zone neighborhoods for the character, the quiet environment, and the family-oriented lifestyle. Allowing this high-intensity commercial use in the middle of a residential and agricultural community would disrupt that stability and erode the qualities that make this area livable. There would be significant safety risks for families and school children. Shady Hills Road already is very heavily traveled with limited shoulders and frequent speeding. Adding C2 commercial activity would bring more traffic, including delivery trucks and commercial vehicles, increasing the risk of accidents. This is especially concerning for school children, cyclists, and pedestrians that use this roadway on a daily basis. Keep in mind, the elementary school is barely a block over south of this parcel. The noise, lighting, and pollution will harm nearby homes. C2 zoning allows use that operates late into the evening, generates noise, requires bright lighting, and produces waste and runoff. These impacts would fall directly on nearby homes, reducing residents' quality of life and property enjoyment as well as value. AR zoning protects residents from these intrusions. C2 does not. The area lacks infrastructure to absorb commercial development. The roads, drainage systems, and utilities in this part of Shady Hills were not were not designed for commercial intensity. Approving this rezoning would strain existing infrastructure and likely require future taxpayer-funded upgrades, burdens that should not be placed on residents for projects that does not serve our community needs. The environmental impacts would be significant and irreversible. The proposed C2 zoning poses serious environmental risks that would directly affect residents and the surrounding ecosystem, to include groundwater vulnerability. This area relies heavily on well water. Commercial uses permitted under C2 zoning increase the risk of chemical runoff, fuel leaks, and contaminated stormwater entering the aquifer. Once groundwater is compromised, the danger is long-lasting and costly to remedy. Stormwater and flooding concerns. Commercial development typically replaces natural ground with surfaces such as asphalt and concrete. This increases stormwater runoff, overwhelms drainage systems, and raises the risk of localized flooding on neighboring properties. Wildlife habitat disruption. The AR zoned land supports birds, pollinators, and other wildlife that rely on open spaces. Commercial activity, lighting, and noise would fragment habitat and push wildlife further into the roadways and the residential area. Loss of tree canopy and natural buffers. Clearing this land for commercial use removes natural vegetation that currently provides shade, erosion control, and noise buffering. This loss would permanently alter the environmental balance of our area.
Okay.
Is that my warning?
That is actually your time up. I think your warning light went off earlier, right?
Okay, sorry, I'm not familiar with this.
That's okay, no problem. I wanted to try to give you as much time as possible. So do you have any final words you want to say?
Yes, for these reasons, I strongly urge you to deny this rezoning request. Protecting the safety, character, and well-being of our neighborhood should be the utmost concern.
Okay,
Thank
thank you.
you.
That was a very good presentation.
Thank you.
All right. Just ask the staff, the property just north of this property, what is that? What's the zoning on that?
Yeah, we had rezoned that not long ago.
To what, John?
That's what I was trying to remember. It says C2 on the property appraiser, but I'm pretty sure we did an MPUD on that property.
Amy Toll, Planning Development and Economic Growth. I believe you're correct on that, and the map is incorrect. It should be MPUD for townhomes.
Yeah, I think Ms. Wilhite, was that your case?
Nectaris Pitos, Planning Development and Economic Growth. The public hearing occurred at Planning Commission, but the item is pending at the board level still. So it's continued to a date uncertain.
And the
It was for townhomes,
It was for townhouse.
townhomes.
All right. Did we get everybody to speak? Amy, did you have more you wanted to say?
No, I'm just here if you have any additional questions.
Okay, are there any more questions for Amy? Okay. Anybody else wanted to speak?
Good afternoon. For the record, Michael Razor, Razor Transportation Consulting. I have been sworn. 19046 Bruce B. Downs Boulevard, number 308, Tampa. I noticed this item on the agenda as I was leaving the office, so I grabbed my report. I wasn't expecting to speak on this today, but I do have some transportation information to provide, as there was opposition testimony in that regard. We did a timing and phasing analysis, which looked at the reasonable yield for the C2 portion, which is approximately 1 acre. The reasonable yield was calculated based on the Land Development Code formula, which assumes 75% of the property is developed with medium to medium-high intensity uses, and the resulting level of service on Shady Hills Road was level of service D, as compared to a level of service D standard. So with this development in place, it would still meet the adopted level of service, and there were no issues with the study intersections. And also, I'd like to point out, and don't have the year here yet, I didn't get to that page, but Shady Hills Road is in the long-range transportation plan, is being widened to 4 lanes from Hernando County to State Road 52.
So, Mike, I realize that there may not be a design done yet. Do we know what the ultimate right-of-way width will be for Shady Hills Road?
John, if that's a question, I don't know. I did not get into right away for this. It was a Euclidean timing and phasing, so I was minimal involvement.
I got you.
Is there anybody on staff that knows that answer to that question?
I think it's in finding fact 12.
Yeah. I was just getting ready to say.
So what does it say, John?
160 feet.
106, and the current right-of-way width is? 60, so there would be 50 feet that would have to come off the frontage of that property to accommodate the widening of Shady Hills Road.
Right.
Is that currently in the corridor preservation tables? I mean, would he be required to give that today if he came in with a development application?
Hi, good afternoon, Commissioners. Bennett Elbow here with Transportation Planning. Yes, sir. So that is from the table of the comprehensive plan. The ultimate right-of-way width is 160. That is correct.
There's currently 60?
And it is currently, yeah, that I need to check on that.
I think Ms. Wilhite's trying to help you out.
Oh, sorry.
Barbara Wilhite, 6327 Grant Boulevard. So that is what the current table says, but from my experience, based upon the project to the north that's still pending, if you look at the transportation tables that you've looked at for the 2050 update, you'll see that they've changed that cross-section or the ultimate width. I wish Nick Earn was here because he'd know it off the top of his head, but it's definitely being changed from that width to a much smaller width. I'll see if I can look it up and get you the answer. If you want to kick this for a moment, and I want you to have the right facts.
Oh, yeah.
So.
No, I appreciate that.
I have it where we
Next.
reduced it, I remember
You've
that.
got it. All right, he's got it.
There's a lot of people helping out with this one.
Sorry about that. William Vermillion Planning Development, Economic Growth. Oh, we reduced this if the Planning Commission remembers, we had a number of projects on Shady Hills Road that brought the widening to the forefront in terms of its timeline, and it was reduced to 124 feet ultimate as the 4-lane.
So,
All right, but we'd still be looking at 32 feet of right-of-way.
In terms of what's required to be given by this project,
Yes.
I can't speak to what should be given for this since I didn't work on that, but that sounds correct to me.
Okay.
well, if that's correct, then finding 12 is not accurate. Because right now it says 50 feet.
Is it necessarily accurate because has that actually been approved yet for a reduction?
Well, I don't know. I'm asking
No, because
last
that's in
staff.
the proposed comp plan, it's not in the new, it's not in the existing comp.
I mean, I think it should be noted, but I don't think finding 12 is
Well-
inaccurate.
You probably should have a caveat, it says something like unless otherwise approved at the time of PSP or something like that. The problem with the way it's worded right now is it's absent, doesn't have any wiggle room.
I mean, can they get right away from the other side of the street anyway? There's a house across the street.
Yeah.
Well, they would have to take it.
Right, but I'm just saying.
The point I was trying to get to, that in this case, depending upon when his development application comes in under current comp plan or new comp plan, at the end of the day, there's going to be, per our corridor preservation ordinance, there's going to be a right-of-way dedication, which then goes to Liam's point that he was trying to make, that after we get the right-of-way dedication and this is C2, that'll be a 25-foot front setback.
The rear setback would, so you would lose the right-of-way dedication plus the 25 feet. And the way the code is written for the rear setback, it calls that when adjacent to residential districts and then adjacent to commercial and industrial, it doesn't talk about agricultural district, which is what the rear would be. And historically, that was always assumed that it was 30 feet. So you would have the right-of-way in the front plus 25 feet and then a 30-foot rear setback.
You could build a pencil on there, right?
I'm not saying you couldn't put something there. I just don't know if the applicant has thought that far through.
Photomat went out of business a long time ago.
All right, well,
I also want to make a comment only because this was submitted for the record was the photos, and I understand that applicant can't see that. In photo 6, it looks like there is yard debris, which is a conditional use in C2. So I don't know if there's a code violation or if that is actually yard debris. It's kind of hard to see in photo 6 that was submitted to us, but just want to note that if that is yard trash debris, then that might require a conditional use.
And I assume there's no permits for the portable buildings that are currently on the site, which I've personally driven by and seen.
that's a question for staff. John?
Yes, that was a question for staff. Well, no, I asked if there were permits for those portable buildings that are there.
Nick would not know the answer to that.
Don't go far, Nick.
Nick just answers the road.
Mr. Chairman,
Yes.
over here. Nick Darius, those planning development economic growth,
Oh,
right here.
there you are.
So we're not aware of any code issues regarding those structures.
What does
So
that mean?
There's no violations. So
So I can just go put a portable on my lot and there's no violation to do that without a permit?
that's not,
Portables are on the adjacent lot. The portables are on the adjacent lot.
They're not on your property?
No.
Okay. All right, that's what I'm trying to understand.
So these are not pictures of the property that we're looking at?
I think what they were saying, that the point of access to that is, looks like it's from this piece of property, but they're sitting on the adjacent parcel. Thank you.
I have a question.
Yeah.
I know there is a rezoning application that is continued to a date uncertain to the north. I'm wondering if that includes, and maybe Ms. Wilhite can answer, that portion that has those two portable buildings, or if the MPUD stops at that boundary to the north. Sorry, Barbara, for putting you on the spot, no rush.
Yeah, Mr. Semino over here.
Or if you know the rezoning, I can pull it up myself over here if somebody knows the rezoning number or something like that.
Well, if you're gonna speak, though, you gotta be on the microphone, please.
Good afternoon, everyone. Joe Semino, 12363 Hampton Park Boulevard, Tampa, Florida, 33624. I was involved in the rezoning to the north. I don't have the MPUD number off the top of my head, but I do have it open here. And we are showing a 124-foot proposed right-of-way with a 62-foot proposed half-width, which equaled a 29-foot right-of-way dedication. And that's to the north.
Okay.
Did that include the parcel with the portables on it?
The applicant appears to be correct, that the portables.
Consensus is no, it does not include that parcel.
So there's a parcel in between.
Thank you, I appreciate it.
And the portables are not on the applicant's property?
Correct.
Okay.
All right.
So,
Is there anybody else to speak? You only get one bite at the apple.
I just wonder if I want to.
I'm sorry, you can't speak from the audience. And if there's anybody who would like to have him answer a question, you're welcome to invite him up.
I'll have Mr. Salato.
But when you come up, it's a good thing for me to tell you right now. You don't come up 2 times or 3 times.
I understand.
Just 1 time.
I just wanted to restate what I said. I understood that the portables were not on that property. It's the means of egress of getting to that property that's being used by the current parcel that's up. That's what I was trying to convey to you.
I got you.
Thank you,
Okay.
sir.
I can see where they're driving onto this parcel and
Yeah, I
getting
can
to the
see that.
portables.
okay, so I still have an outstanding question of why the property to the north, we're asking for 29 feet, but then we have an agenda memo here where we're asking for 50 feet. Can somebody address that question?
Mr. Chairman,
Yes.
Nick Trios, Pitos, Planning Development and Economic Growth. The finding of fact number 12 is referencing 160 feet based on the current comprehensive plan. So that's the actual number that we have on the books right now.
Okay.
We've worked with the county engineer and obviously in other projects where we identified an alternative right-of-way width for Shady Hills Road from County Line Road on the north to Bosley on the south. That's 124 feet in the Pasco 2050 comprehensive plan update. And that would be consistent with the conditions of approval that were mentioned in the MPUD to the north of this property that Mr. Semino had discussed. So we're not referencing the 124 feet because that's not yet approved by the Board of County Commissioners.
Is that being done like through an LDC variation of some kind?
an LDC variation or alternative standard to the right-of-way.
Well, is it being done through some kind of variation to the code, the one to the north?
Yes,
Okay, well, then that would explain it.
yes.
Okay.
Okay. So is there anybody to speak on this here, ask questions here that has not spoken? If not, the applicant has an opportunity to respond to any questions.
Well, I still have one more question for staff.
Okay.
So how confident is staff that once you apply the required right-of-way dedication and the setbacks, that you can fit a building on this site?
What's the depth of that
What is the
northern
dimension on
line?
the top?
Northern line.
Yeah, what's the depth? There's no numbers there.
The property appraiser says it's just shy of 200.
200 feet.
199.99.
So you have to set back, what'd you say, 50 feet from the back, William?
Ooh, zoning question. 30 feet from the rear, and then it would be the right-of-way with whatever that was determined plus 25. I will say, since the reason why I was asking about the parcel to the north on if it was included in the MPUD or not, because if it is approved that MPUD, that setback would be different because it would still be C2 adjacent, then that could be a 0-foot setback.
So in this case, Liam, his rear yard is the easement.
That's why I was asking
So
where.
the setback
his-
line's gonna get measured from the other side of the easement, not
Correct.
from
That's
what
why I was
appears
asking
to be the
earlier
back of
on-
his lot.
Subdivision?
Correct, if he was going to subdivide the property. So it would be measured from the other side of the easement, but if he subdivides, it would be 30 feet.
Correct.
Are those two segments that we're looking at now under two different ownership names?
No, the easement area in this 1 acre portion is all under one owner.
And do we know, does anybody know if the gas easement is an exclusive easement or is it a non-exclusive easement?
It is a non-exclusive easement.
So in theory, if it is non-exclusive, although he could not build a structure on the easement, he could potentially build parking and/or storage on the easement.
Correct. It is a non-exclusive easement, which enables the owner to build parking on there. And that's probably why, based on the conversations with the client's engineer to date, they would probably not subdivide that parcel.
And
so then they would be able to use the rear portion of the parcel towards their setback.
Is it strictly a gas easement or is there power lines there too? There power, I see a power
Power
transmission
easement.
tower in the photo. Okay, well, it may be a non-exclusive easement for gas, but Duke's gonna have something to say about under their power lines.
We have met with Duke, we have met with Duke Energy on site as well to clarify what we're able to do.
So are you able to provide us any type of conceptual development plan?
No, because it's going to be a very flexible, small building that will be designed based on the setbacks once we get the zoning approved. So that's why the client chose to wait to get a development plan in place beforehand.
You said the client, I asked you before if you were an attorney.
No, I'm not an attorney.
Okay, what's your role?
My role is that I just represent the applicant.
You called him your
I'm a,
client.
I'm a real estate broker in the county.
Okay.
Amy, did you have something you wanted to insert?
I was just going to also confirm that we spoke to Duke and they didn't have any opposition to this change as well.
Okay, well, I still need you to answer my question, which is, or how confident are you that when you apply the setbacks in the right of way that a building can be built on this property?
I measured, once setbacks were taken into consideration, measuring from the easement, the west side of the easement, I'll call it, it was about 144 feet of depth available to put a building on. Which, of course, as you move south into the triangle, it's gonna shrink a little bit. But at the very north end of the site, it's gonna be about 144 feet.
And only the little triangle is proposed for C2?
Correct.
And is there any other commercial property in the immediate vicinity? But it does appear that there's some C2 zoning along that stretch of Shady Hills?
Correct.
With okay.
Mr. Chairman?
Yes, I'm sorry.
Just to facilitate the conversation a little bit with regard to the rural character area. The rural character area, it ends on the west side of Shady Hills. And in the Pasco 2050 comprehensive plan update, the boundary of the rural character is actually gonna get pulled off of Shady Hills by one parcel depth from the road, so that Shady Hills Road properly is, the whole corridor is outside of the rural character area. The subject property, as well as the C2 that you see on the map there, those are in the ROR, future land use category, which will remain as part of Pasco 2050. So these are areas that were designated mostly non-rural, according to the comprehensive plan. The same is going to be true along County Line Road, where the rural character area will be pulled off of County Line to respect the commercial depth that's fronting along County Line Road, going west from Shady Hills.
Okay. So the staff's recommending approval.
Yes, sir.
Question for staff, as I read the background and what they're actually asking for, and I know it's C2 zoning, so it's not really use prohibitive, but there's a statement in there that says they do allow for the use of a contractor's office and associated storage. And if I look at the C2 zoning requirement, when it talks about contractor's office, and there's where is it?
It's number 11.
Number 11, it says all storage shall be inside the building or in an enclosed area not visible from the right-of-way. Does that, so that restriction would be on the storage? It couldn't be outside storage of contractor materials, et cetera, so, okay. Just wanted to clarify.
Mr. Chair, it's up to Planning Commission what you do with it, but if this is approved, I think Planning 12 needs to be changed to say that it should say unless otherwise approved at the time of preliminary site plan or preliminary development plan review, that they have to dedicate 50 feet. I don't think it's appropriate that we're considering a variance for the property to the north, and then we're not willing to at least consider one for this property.
Amy Toll, we can add that standard language.
So moved. To approve.
Okay. So we have a motion to approve, subject to the most recent comment. Any further discussion on the motion? Do I have a second?
I'll second that.
Further
So,
discussion?
yes. So along the west side of Shady Hills Road, adjacent to the northern portion of this property, the future land use is COM. The zoning is C2, and it goes all the way up to county line. I know there is a pending MPUD for townhouses, but it's not yet been approved. One parcel to the north of this. My first thought was, we're asking for C2 out here in this rural area, and this would be spot zoning, but after reviewing the map and seeing all of the C2 on the west side of Shady Hills and then all the way up to Shady Hills currently on the east side, this just appears to be a natural extension down to the apex of the triangle. I will caution the applicant that, as per Liam, who used to be our in-house zoning expert, or one of them, you're gonna have fun trying to develop this property because you're gonna find that there's not a lot of buildable area. And I would tell you that perhaps you should have gone and seen an engineer and had some conceptual layout before you did this, but that'll be your gamble, I guess. But I don't find this to be spot zoning, and it just appears to be a minor continuation of the C2 district that's already there.
All right, any further discussion? We have a motion, we have a second. No, if there was no further discussion, all in favor of the motion signify by saying aye.
Aye.
Opposed, like sign? Okay, motion carries.
I would just like to thank everybody out there who helped with that item.
Yes.
Real team effort.
Is that like an amicus brief?
All right. PC 4.
Good afternoon, Amy Toll with Planning Development and Economic Growth. The item before you is PDE 26-2111. It's a zoning variance requesting an amendment or a variance to LDC section 530.13A, supplemental regulations and waterfront property, and LDC section 1014A, docks and seawalls visibility. The subject application is in the name of VA-2111 FAM variance request. The subject site is located in an R4 high-density residential district with a future land use of Res 9, residential 9 dwelling units per gross acre. The purpose of the variance request is to reduce the mean high water line enclosure setback from 50 feet to 5 feet. The location is at 3872 Topsail Trail, approximately 1.2 miles west of US Highway 19. Here is a location map showing that the subject site is in the River District of the West Market area and within the urban service area. Here's a context map highlighting the subject sites and the aerial imagery. Here's a zoomed in version of the aerial imagery. The future land use is Res 6. Res 6, I think that says, I'm sorry, I can't read that. Zoning is R4. Here's a concept plan showing or a site plan showing the actual home with the pool and the highlighted setbacks that are existing. The project overview, so the applicant has requested a variance to reduce the mean high water line enclosure setback from 15 feet to 5 feet in an R4 high-density residential district as required by the Land Development Code, Section 530.13A, supplemental regulations for waterfront property, and by LDC Section 1001-4A, docks and seawalls for visibility. Here's the zoning code for the waterfront property and the zoning code for the docks and seawalls. The recommended conditions are that the property owner may request to comply with the following items: limit the variance to the lot area as built, comply with all other maximum and minimum bulk standards, acknowledge that the site is subject to the flood damage prevention ordinance, acknowledge an appeal may be filed, and the effective date of the approval by completing the acknowledgement documents. And with that, we recommend to approve the proposed variance with conditions as set forth under the recommended conditions section below. I'd be happy to answer any questions you might have, and then we also have the applicant here to advise as well.
Is it a fact that the applicant applied for a permit for this structure and was granted the permit?
He applied for the permit, the site plan was approved, and, well, he applied for the site plan, the structure was built based on the approval from the county. He went for a final permit, and then
What do you mean he went for a final?
for the certificate of occupants, or the final permit to grant the enclosure.
The final inspection?
Inspection.
He was issued a building permit for the enclosure.
Thank you. Mhm.
So there was an error by the building department in issuing the permit?
Correct.
Okay.
All right, any other questions?
Yeah. So is this a staff-initiated variance?
No.
Did the applicant have to pay the fees to apply for the variance?
I would guess yes. Yes, yes. Yes, he did.
Okay.
Thank you. Anybody else?
Is there anybody else speaking to this next meeting as the applicant? Is there anybody else here? Go ahead, let them speak.
All right, I'm sorry, you're the applicant?
I'm that.
Okay. Is anyone else here to speak on this besides the applicant?
Mr. Chair, the only individual I have signed up for this item is a Mr. Doug Tilley.
Could I ask the applicant a question real quick?
Yeah. The applicant will come up to the
The applicant's
microphone.
entitled to make a presentation first if he wants to make one. Sir,
Right.
you need to let the applicant speak first if he wants to speak.
You want me to speak first?
He's just coming up to answer a question. Could you,
Did you want to make a
state
presentation
your name?
about your case?
My name's Mark Weiss. I live at 4903 Blue Heron Drive, 33546. I actually live in this neighborhood and have for a while. I have a statement from the owner of the home. The owner bought a new pool with an enclosure. The pool was done with a permitted footer for the enclosure. The permit for the enclosure was submitted and given. Everything was built. Upon calling in final inspection, this issue was brought up. This particular property is in a corner of the very end of a canal, so it has no blockage or views of anybody around it. The house next door adjacent to it, which is actually facing, it's right next door. Their enclosure is only 8 feet. There's many places on these canals of this older neighborhood where this setback is not, they're not all too in compliance. Some of them are very old. As far as the letter from the homeowner, I would like to read it. I am writing this as a homeowner, deeply frustrated by recent events. Your department granted a full permit for the pool enclosure on my property. I followed all regulations, hired a licensed contractor, spent thousands of dollars completing the structure. This enclosure was an integral part to my overall project, which included the pool itself. Without proper enclosure, I would have never installed the pool, as a mosquito issue in our area is severe. Now, after it's built, I'm told within the setback and requires a variance, implying that I may need to remove it. This is unacceptable. Your approval process should have prevented such costly mistakes. I trusted the permit meant everything was in order. The financial burden and emotional stress this has caused me is immense. I expect the county to take responsibility and ensure a fair resolution without further hardship on my part. So I understand the code. Like I said, I live on waterfront property, and the 15-foot setback after that, if you're in a backyard, these houses are all different. Some are setback, some are forward, but it would impede people's view. In this case, it does not, and I believe it should be passed.
Sir, what is your relationship to the owner?
I actually am the contractor for the pool enclosure, but that pool enclosure was sold from a pool company, okay? One of the several pool companies that I built pool enclosures from. He asked me to handle it. And I did so because, he doesn't speak very good English, and he's been there a long time, and it was really the pool whose fault is it?
Yeah.
Everybody, we all followed the rules. We got the permits, we built the things. I build about 300 of these pool enclosures a year, all over the Tri-County area. So we're pretty particular, we're a good company, and we've been around. So when I saw his hardship, and I volunteered to be his representative, and I filled out everything for him.
All right, well, thank you very much. Did you have another question, John? He'll come up again. Yeah, why don't you stay up close here?
Oh, okay.
All right, so if you could get your name and address,
I'm
please.
Doug Tilley, 3866 Topsail Trail. I own the parcel west of Mr. Sham. I have no problem with it. I think the question here was, half of his property is landlocked, and the other half is on the water. He's in that corner there, which is also going to impede a dock or anything with water rights there. But as far as obstruction or that, if you're, up in the middle of the canal and you have that sticking out, then you're obstructing the so-called water view, canal. But I don't have any problems with it. I used to be able to peek over the fence and see where the tide was, but, and you do need a.
Get you a ladder.
Yeah, but I go on the roof and I can look.
Okay.
But I don't see any issues there, and neither does the gentleman on the other side of it, because with the location of it being on the side there. You've got quite a unique situation in that subdivision with the water. No backyards, because it goes right to the seawall. And, but that's, and I think there might have been a question there about the variance because of it half landlocked there. The back of his property meeting the side of our backyard neighbors. So I think there might have been and there's probably someone now going, well, he did it, why can't I? You're gonna get that. But, I don't feel nobody's at fault here. It was just overlooked, The inspectors weren't sure, the contractor wasn't sure, somewhere else it might have been more of an issue.
All right,
But
well, thank you.
I fully support all this. I wasn't planning on showing up, and then I heard there were some people that might be opposed to all this. It's like, why? But that's all
All
I
right,
have to say.
thank you. We appreciate you
Okay.
coming.
Okay, thank you.
Thank you very much. All right, is there anything the applicant would like to add to that?
No, really, like I said, it's a pretty much open and closed case. And the other thing is, like he said, these certain areas at the end of these canals, they're not even allowed to have a boat ramp. There's certain houses in certain places that because the area is in a corner, only 15 feet maybe out of his 50-foot property is seawalled, but you have the other one coming in. So those are irregular situations, but they are on certain canals in that neighborhood. I think it was just unfortunate for the man. And it's been 2 years because of the flood, so everything got pushed back. So he'll be happy just to see this go through and know that he can keep his pool.
Yeah, I'm sure he would be, yeah. Okay, well, thank you. All right, so do I have a motion?
I'd move to recommend approval. Well, we are the decision.
Not a recommend, this is a,
Okay, well then move to approve the variance.
Second.
Have a motion and a second, further discussion of the
Yes.
motion?
When you make a mistake, you admit to it and you fix it. And Mr. Engel, I hope we will refund the applicant's fee for the variance. That's not his fault. His contractor applied for the permit. He was granted a permit. I'm very familiar with this section of the code because I have done a lot of pools in Gulf Harbors. I know all about this section. The building department made an honest mistake. I'm not saying there was something bad happened, but when you make a mistake, you admit to it. Why should the applicant have to pay? They had to pay the cost of advertising, they had to pay the application fee, whatever other paperwork they needed to fill out. Somebody should eat that. You know, we just recently had a case before the board where the building department issued a permit for a mobile home where they shouldn't have, and the county had to buy that mobile home and buy the guy a modular home to make it legal under the zoning code. I don't think it's that much of a burden on the county to eat the fees for this one. I'm disappointed, and I'm gonna tell you something. I'm trying to say this without being overly nasty to staff, but I thought it was very disingenuous to come up here and not include in your presentation that this was an error made by the building department. That's a material fact to this case. You know, it was omitted from the presentation. I had to ask for it.
Well, thank you, Mr. Moody. David Engel, Planning and Economic Development Director. I agree, we should own our mistakes. I do have the delegated authority to waive the fee, and I will do so. I wasn't aware of all this background. Thank you.
Thank you, David. Appreciate
Thank
that.
you.
All right, we have a motion, and we have a second. All in favor of the motion, signify by saying aye.
Aye.
Opposed, like sign. All right, problem solved.
The next item on the agenda is item PC5. It's PDE 267897, a zoning amendment in the name of Mitchell 54 West MPUD and M&M Route 54 West LLC. It's a substantial amendment from MPUD Master Plan Unit Development to MPUD Master Plan Unit Development to allow for the removal of the transit-oriented design and mixed-use trip reduction measure requirements and to reduce the non-residential entitlements to 460,000 square feet of commercial and add 240 hotel rooms and associated infrastructure in southwest Pasco County, located at the southwest quadrant of the intersection of State Road 54 and Little Road, containing approximately 330 acres, to be presented by staff.
Good afternoon, William Vermillion, Planning Development Economic Growth. As previously mentioned, this is a substantial modification to the Mitchell 54 West MPUD PDE 267897. Here is the location map for the subject site of the existing MPUD. For those of you familiar, this is right behind the Sprouts over there on 54 and Little. This substantial modification is to remove the previously approved requirement for transit-oriented design and mixed-use trip reduction measures, MUDRM. So as I move forward and I say TOD and I say MUDRM, it's because both of those are a little bit of a mouthful, so I'll abbreviate them as I proceed here. It's also to reduce the existing entitlements. I do have a slide moving forward that shows the before and after and the built entitlements on the subject site. It will end up being a total of 460,000 square feet of commercial retail, 240 hotel rooms, and the associated infrastructure on approximately 330 acres, This is at that southwest quadrant of the intersection of Little Road and State Road 54, right behind the Sprouts there, and just north of the Bryant Square development that was a part of this MPUD. Here's the location map. As you can see, the roadway infrastructure is already built on the subject site as a part of the original MPUD approval in 2015, with the roundabout there up to State Road 54. The current zoning map reflecting MPUD and the PD future land use. Here is the existing entitlements, the originally approved entitlements, and the proposed entitlements. You can see there in the approved, it was originally approved for 980,000 square feet of commercial, 800 residential dwelling units, and when it was approved, it had an older loom that allowed the exchange of entitlements to multifamily, which is something that PDE has moved away from in the future. So as a part of the modification to this, the loom being proposed prevents the conversion of any non-residential land use to a residential land use. The existing entitlements, 175,000 square feet of the commercial retail are currently built, which is that shopping center. 240 single-family detached and 422 townhomes are currently constructed, so that the new total entitlements reflect those existing and proposed, the total of 460,000 square feet of commercial, the 662 residential dwelling units because they already exist, and the addition of 240 hotel rooms. It is worth noting the hotel rooms were a previously approved use as a part of the original 980,000 square feet. Whenever the applicant proposed to reduce to 460, we specifically called out 240 hotel rooms as a separate entitlement from commercial. It actually ended up being a little bit easier in terms of estimating the impacts transportation-wise, because when you study commercial on its face, it is a little bit of a different trip generation than hotel. The impacts infrastructure are a little bit different. And then as I move forward, there are some implications to the removal of TOD and mudroom, the most substantial of which is going to be in a companion EDA at the board, which is a clawback of the reduced fees that were originally granted to the development and received COs for. So those fees were already paid. So the applicant is responsible for an approximate $3.591 million repayment to the county as a part of those reduced fees that were granted, either with the 25% reduction for mudroom or the 50% reduction that's with TOD. All the transportation mitigation requirements from the original MPUD, as I move forward with the master plan, they all remain the same because with the reduction of entitlements, the actual trips being generated onto State Road 54 and at the different intersectional locations has been reduced. And I guess it is worth noting that even though this project is having less transportation impacts, and their mitigation requirements are still the same as if they were doing the original 980,000 and the original 800 residential. This is the original master plan, so the subject side of the modification within the MPUD is actually just a portion of, you can see up there in that red commercial area, you can see a little bit of the roundabout that's currently built. But more importantly, the first exhibit that I'm going to be showing from the packet that was sent to the Planning Commission is the binding concept plan, which shows the building footprint of several commercial end users here, as well as the existing transportation infrastructure. And as I move forward, what really gives the binding concept plan color, both literally and figuratively in this case, is the binding connectivity plan, which is now shown in the slides, and the applicant does have a printout of the new connectivity plan. This was revised this morning as the applicant continued to have meeting with the surrounding neighbors. It's also been sent to the clerk's office. Each of the color coordination that's occurring there is showing the existing or proposed widths of paths, as well as pedestrian crosswalks and flashers throughout the site, allowing the existing residents to be able to navigate the existing infrastructure as well as the newer infrastructure that's coming in terms of the parking and access ways. It also shows the signalization that is required of this project to the north, that's existing cattle ranch way in 54. It's a requirement to be signalized, as well as if you move over to the west, that connection will be fulfilled by this obligation. Currently, there's a little bit of a stub out there to 54 on Meadow Way, but it doesn't fully connect to 54. This will become another secondary access point for this particular pot of development within the MPUD. There is also a binding material palette, which is a little bit unusual in an MPUD, where the applicant was wanting to commit to specific building materials for a unified pattern between the different non-residential users that end up locating within this site and co-locating with one another, that the themes are matching. Secondly, there is a binding exterior landscape plan, and I'm gonna click through these slides rather quickly because there's quite a bit of information on all of these. This is the overall binding exterior landscape plan, in which there's a key associated for the color, which shows what the buffer is. So as I move forward, it's now breaking down the individual colors into what they look like in the specific plant species, width, and typology that's associated with those buffers. This particular section here is showing the walls as well as the buffer that would be seen from the existing residential, and how that relates to the scaling of the buildings that are being built within this MPUD that abut the residential lots. As we move forward here, this shows the various buffers, both type A, B, and D2. And as I move forward here, which I failed to mention on the connectivity plan, the multi-use path along State Road 54 is also being improved with this proposal of the MPUD. You can see there that the trail kind of meanders, but the applicant worked extensively with the power company to make sure that they could fit an enhanced buffer within the right-of-way and still not affect the overhead power lines. This is an example of some of the parking island buffering. And then as we move into the perimeter buffering, the patio, the service screening, and water management buffering. Again, this is the walls and the intersectional nodes, particularly the roundabout, what the roundabout looks like, and what it feels like from a pedestrian scale with these plantings. And with this binding landscape plan, the two variations requested with this project from the code are both from that 9052, is specifically D5 and D4, which deals with the buffering requirements. And the reason that the applicant is requesting these is that typically when the preliminary site plans and the construction plans are submitted, the buffering and landscaping is done on a parcel by parcel basis. And what they've done here is treat the development holistically with its buffering instead of waiting until site plan to treat these parcels one by one, buffering uses from one another, just in compliance with the code. And given that, PD was amenable to this request. I will also back up whenever I went to the connectivity portion. The other signal that's worth noting that isn't a developer obligation, the signal at Mitchell Ranch and 54 as well built, runs north to south to Mitchell Ranch, and then Mitchell Ranch connects to 54. That is in the county's CIP. Design is underway this year in fiscal year 26, with construction expected to kick off in fiscal year 27. With that, it comes with a recommendation of approval with conditions from PDE, and I'm available for any questions.
All right, so do we have any questions? Anything? All right.
Thank you.
Thank you. Well, hi, how are you?
Hello, Barbara Wilhite, formerly Barbara Wilhite, 6327 Graham Boulevard, Newport Richey, Florida, actually here for an applicant. Wow, those presentations are getting better and better. I shouldn't have woken up at 6 o'clock this morning. But I do have my own PowerPoint, and I'll run through it. A lot of what he was saying, I've forgotten. I've been working on this so long. We meet every Monday as a team, and we obsess over every detail about this project. And Mr. Vermillion remembers some of those details even more than I do. approved versus proposed, I think Will went through this. A hotel is a permitted use. We were just trying to work the entitlements in a way that tried to make sense and make them clear. I know there's a lot of social media, because I watch it, concern about a hotel that's already a permitted use. It could happen today on the property. The approved versus on the residential side, there you can have, the loom allows unlimited exchanges from commercial to residential and apartments. This particular client, the applicant here, has approvals for 684, can't read that far, 684 5-story apartments at the moment.
64.
64, all right, thank you guys. And but by what we're going to do is we're just going to wipe all of the residential entitlements out. What hasn't been used by this amendment, they're gone. The ability to convert commercial to additional residential apartments is gone. The ability to construct the apartments pursuant to the approvals the clients have are gone. So we've just been really trying to be thoughtful about how we move this forward in a specific manner. This is a build out of this project. This is the end of Mitchell 54 West MPUD. So we can, when we do that, we can clean up the paperwork. I would say that there are single family detached homes, 240 that have been built, and there have been townhomes, 422. Also in Will's presentation as single family detached. A large portion of those townhomes are owned by Invitation Homes. They are billed for rent. They're rented. Along our southern boundary, they're all rented. Along most of our west boundary, at least to the BJ's, the adjacency is rental townhomes. Thought Will did a great job of going over the infrastructure. I would be redundant if I went through those 3 improvements there, because he went over them with you. The mobility fees, not only does the repayment of the $3.5 million for the TOD versus urban, and mind you, when they repay that for all the Lennar project, Bryant Square, every residential permit, and they're also repaying for every commercial permit in the Sprouts, that commercial project to our west. Our estimated fees, about $2.7 million for the project you see on the binding concept plan. Those are 2025 rates. Of course, your rates have gone up, so we'll see how that works out. It'll probably be more, effective July 1st. And then we also, the developer had in their economic development agreement the ability to get credits, mobility fee credits for the construction of what we call the internal spine road, and that's Legend Pasture Road and Bear Landings Way. So I think if you look at the infrastructure, it is significant, because those are a traffic signal that when I go out there, it's hard to get across that road. 3 lanes of traffic. And I can also tell you that our traffic signal is going to line up with Mrs. Spears' property. I know she has passed away recently, so we'll see what happens with that property. But the infrastructure is going to be in there if that ends up being developed in a different manner. So giving the residents more ways to get out, better ways to get out, will be a benefit of this project, as well as giving the county some nice bit of mobility fees. Hopefully they can be used in this area. What comes to mind for me is Mitchell Boulevard Extension. It's always been an issue how to get that done. This will give the county quite a bit of money. Hopefully maybe that'll get that road done finally, because that's a bypass to the Little Road 54 intersection. As Will had mentioned, we did quite a bit of work. We had a neighbor that collaborated with us on the binding connectivity plan. I didn't know. We've been representing this project for quite a while. Did not know that they had quite an extensive trail system within this project, including looping around this project. And it connects to the high school and the middle school, and it comes up and it goes around. And so we hadn't had anything. We had a great connectivity plan based upon, we looked at where there were gaps and where we could enhance, just based upon our project. But one of the neighbors in Bryant Square, owns one of the homes out there, said, you need to look at these issues relative to this trail and these driveways and the trail and connectivity and safe crossings of driveways. And so we did quite a bit. We added the solar flashing beacons at 8 crosswalks. We added at our southern portion of our project, where Home Depot has their southern driveway, we have a no right turn, so we limited that turn movement that goes down towards the residential portion of the project. Similarly, on the BJ side, we're limiting the left turn, so that, again, there's no left turns. They'll go from the project down into the residential portion. We added trail stop signs so that the trail, folks on the trail will know to stop at those driveways. This morning at 6:30, Joe Semino and Steve Henry and I decided that there was a 5-foot existing sidewalk along the east side of Bear Landing Way. And we looked at that and we said, how can we make that an 8-foot? So that, again, the residents can have better ways to move around as our project comes online. Our project was always anticipated to come online. You know, when you look at a project that's got had 980,000 square feet of commercial approved, I don't think I'd represented a project that has that much. It was always anticipated that we'd be developing this property commercially. But in any event, so we thought that would be a good benefit, and we were able to fit 8 feet, so we'll improve that sidewalk and help people move around. We also added a lighting note to make sure there was special attention made to the driveways so that there's good lighting between the pedestrians that might use the trail in the evening or at sunset and the lights when they come on. And other conditions of significance, we waived live local and all the binding plans that Will went through. And I had forgot about, there's special condition number 9 that we did relative to what can we do with our retail? Because we have some buildings that we don't have end users for. So we actually limited, we only can have 1 drive-through. We have to have in our parcels G and F, the thought was on our end caps, let's make sure it's a place where you can go and sit outside and eat. So we actually have a condition that makes that happen. We looked at the 2 parcels. There's 2 parcels at Little Road and Bear, I'm gonna mess up the name of that road, Bear Landing Way. These are the most interesting names that Mr. Dewey Mitchell put on this project, huh? But there's 2 parcels, vacant parcels there on Little Road. We have standards for those, but we can and can't do there either. So I hope you can see the attention that's been put into this project to make it a good project and to fit well. It's been very thoughtful. If you have any questions, my team is here. Joe Semino, Steve Henry, we are here, so.
Barbara, just one question. Do you have end users for any of the out parcels?
We do.
I'm only asking because obviously BJ's and Home Depot aren't exactly the most, not a lot of people walk to those uses. I mean, those tend to be more drive up, put a bunch of goods in your car type uses. Do you have uses do you have end users for the out parcels along 54 that are?
Out parcel C and D, we have those end users. Are there plans in, Joe? They're not quite yet. They're not in yet. He's working on their plans. And that's actually the form that you'll see with the little courtyard in the middle between the 2 so that there's outdoor space. So that form is there. Out parcel A is a bank. C and D are restaurants. B and E are not decided yet. G and F not decided yet. I did want to say one thing with regard to the landscape plan, and I think Will presented it pretty well. When you look at the neighboring project, and I go over there and shop every once in a while, and if you park here and you need to go there, because it was different parcels when they were developed, there's this raised landscaping island. And so I got to go from here to there. I got to go through it with my heels, because I always wear heels. And so I made this team. I said, I want to have a landscape buffer that's a Barbara Wilhite landscape buffer, that I will not have to go in my heels. So we have one, and it's the one that goes north-south between BJ's and Home Depot. It's going to have a nice sidewalk. You can't see all these details, but this kind of details we did with the team, and they were very generous to make sure that I could walk through my heels and go really. So that's the kind of detail that we went to with this, to make sure it's walkable, even if, because you may walk from Home Depot, I probably would, to BJ's, and so I'll be able to walk on a nice sidewalk and won't have to mess up my heels.
The C and D are more sit-down restaurants that people would actually walk to?
Yes, C and D are sit-down restaurants, yes.
Okay.
Mhm.
Anything else, Barbara?
No.
No. Any questions from up here? All All right. Do we have anybody on the schedule to speak here on this?
The only individual I have signed up for public comment, Mr. Chair, is a Miss Bridget G.
Okay.
Good afternoon. Commissioner, I don't know why I'm so nervous, but I'm nervous.
That's okay. Just take a deep breath. Take a deep breath. Okay, first tell us your name.
Bridget Gilio. I live at 8322 Corner Pine Way, Newport Richie, in Bryant Square. I oppose this file. This amendment removes the transit-oriented design and trip reduction measures required in the original approval. The reality, that means no transit lanes, no pedestrian connectivity, and no rideshare controls. It strips away all promised traffic mitigation. The big box impact, we are being told BJ's Wholesale Club and Home Depot will be added as well. These massive anchors generate heavy, continuous commercial and consumer traffic all day long. Having these big box stores will not look aesthetically pleasing to homeowners, especially the townhouses that face back to the area. The hotel bottleneck, layering a 240-room hotel on top of BJ's and Home Depot, with morning departures, afternoon check-ins, and nonstop Uber loops will completely paralyze State Road 54 and Little Road. There's a roundabout hazard. We have a roundabout, but seeing the driving skills of many motorists, it can already be deemed as dangerous. People already have driven across the roundabouts rather than going around it, knocking over signs. Mixing big box retails and high volume hotel traffic without already unstable high collision roundabouts guarantees daily gridlock and slows emergency response times. The environmental crisis, this adds an environmental crisis disruption to our local wetlands. It's immediate. It's pushing alligators into our residential areas, destroying sandhill crane nesting grounds, forcing wildlife onto roadways and onto our driveways. We walked outside, there was an alligator under our car. The infrastructure deficit, our utilities, roads, and public services are maxed out. We cannot absorb this massive commercial hub while eliminating required protections. Allowing developers to secure approvals with safety safeguards only to erase them later sets a dangerous precedence. Traffic with the schools are also problematic. Some residents already on the Bryant Square Facebook page are having issues with people crossing, and what they're saying is, let's block the crossroads, the through streets, but that's against the law. Parking overflow in neighborhoods, parking is already a nightmare. The HOA tells us there's a certain time we cannot park, but then Pasco County ordinance says there's another. So parking tickets has been a rise, so you guys are getting money. And then for the protection of our roads, our environment, our public safety, I respectfully request to deny this modification. One of the concerns is that many of the homes are invitation homes, so how many residents versus tenants? Thank you.
Okay, thank you very much for speaking. And there's no one else then? Ms. Wilhite, would you like to come up and answer some of those questions?
Absolutely. Barbara Wilhite for the applicant. So what we definitely are doing is stripping away, we are adding. A lot of because we entitled this property originally, I didn't entitle it actually, it was entitled by somebody else, but when it was entitled for 980,000 square feet of commercial, there's a lot of requirements. And those requirements aren't going away, even though we're developing less here. We very carefully looked at the connectivity, as I mentioned, and what Mr. Vermillion mentioned. We looked at everything, what's been constructed, what gaps are what's missing, and we even went even further, working with our neighbor to make sure we addressed interactions between pedestrians and vehicles. Transit still like it was on the original plans in those locations. I know you heard about the townhomes. A lot of those are actually mostly a multifamily. At least a portion of them to our south and to our west are really more of a multifamily use as rentals. The hotel location, because it's got a lot of, I watch social media. We have a binding concept plan, so the hotel is not going here within this area, because we have exactly what's gonna go here is on this plan. If there's ever a hotel, it would be on the parcels, the vacant parcels on Little Road, if there's ever one. Roundabout, we are, if you look at the landscape plan, we have extensive landscaping proposed in those areas, so I think that'll be an enhancement to what they see today. As far as environmental goes, this property was mass graded years ago. A lot of this infrastructure is already in. It's kind of just a hole in the donut and finishing the project. But Mr. Semino reminded me that the county does still require, and I guess the state requires you go back through the Gopher Tortoise, so that if Gopher Tortoises decide to move in after the mass grading, you still have to look for those and mitigate them by removal if they exist. So it's an amendment to a plan that's already been in place. I know sometimes residents don't know those kind of details, but this has been approved for our commercial use and a pretty large commercial use for a long time. So thank you.
All right, thank you very much. All right, any questions, discussion?
Do we need to receive and file the handouts?
All right, so do I hear a motion to receive and file the stuff that we were given earlier?
So moved.
Ms. Wilhite?
A second.
Okay, any further discussion? All in favor? Signify by saying aye.
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 Opposed, like sign. All right, so received in the file. Is there a motion on this application?
I actually would like to, before you make a motion to move and approve, just note that there is a school to the south of here. There are two schools actually. And for somebody who lives in this area 5 minutes down the road who frequently, weekly visits that shopping plaza, there are a lot of kids out there that are on e-bikes and e-scooters coming in and out, going to that plaza. I have a feeling they're going to be doing the same for this. So I really appreciate having all those flashers in there for those kids. As a matter of fact, I would imagine after school gets out, those kids now start going through that way to that plaza after school. So I really appreciate all the connectivity that's in this binding connectivity plan and those flashers. So I just want to note that for somebody from the school district perspective, but also for somebody who frequently visits this and sees those kids there.
All right, a motion or second?
I'll second.
Approve item P5.
I'll second.
A motion and a second. Is there any further discussion on the motion?
I just like to add that, I'm appreciative for all the attention to detail and all the things that were added to this plan. I think that it's added a lot of value to and a lot of the perceived probably problems with the big box, with all the provisions and all the landscape requirements and all of the architectural type things that are included in here. I think that they've gone above and beyond what we normally see.
I agree.
Yeah, and much better than what was originally planned for that site. And when I drive by that site every day, right now, I think how ugly it looks. It's just cleared desert. And I think this will be a big enhancement to that area. So all in favor?
Aye.
Aye.
Opposed, like sign? Okay, motion carries. Okay, we're gonna take a little bit of recess, 10-minute recess, come back.
We still got a comp plan workshop to do.
We're done by now.
Oh, I agree. Yeah. Buy the mold, buy Well, that just tells me there's a problem, or there's either a training problem, or maybe the zoning reviews need to happen in this building. I agree. That's what I'm saying. And I just thought it was disingenuous. It wasn't. So it goes. Now the tough one.
Oh, yeah, immediately. Response to documentation was never provided. Response
Well, she's probably just saying, you know what, I said, well, you can't do that. Well, it's not like fire risk. Anytime I want to pick it up.
You're smart enough to start understanding your congregation. You are.
Do you know what he does? He passes accommodation.
Just he's like,
He'll go, excuse me. We need to understand what she's saying. She said that, and I thought. So that's why
Done.
Well, no, this is what vacation home.
Seriously, this is what you present. This is how he's,
Just to start the conversation.
STEM camp. What teacher said?
I'm not gonna fact check you. I feel like it's. Thank you, sir.
So it's a 6-day.
Stop it. Gosh.
I got it. That was most impressive.
But the roundabout too in HOA. We will go the wrong way.
Nope, I'm not Joe. I do not play Joe on TV. Yeah. Have you spoken to Denise?
Chatted with her, but not. I'm pretty sure I almost saw you at Pasco the other day on Monday.
The one in Western Chapel?
Yeah.
That's where that's the one I stop at when it comes on the way home.
Well, you know what, I wasn't sure it was you at first, since I'm so used to you being in a suit. So
Oh,
I had like, I went in for one thing, I was walking out with a bunch of stuff.
Yeah,
I did not have.
always the way I do
So I was
it.
walking by, and I think I walked right past you, and I didn't do a double take, I was like, is that just David? And I didn't want to come stalk you down with things in my hand, and be like, David!
Could you help me carry these?
It might have been after my doctor's appointment, so I probably didn't have a suit on.
You did not have a suit on, because that's what made me think, I was like, oh, was that David or not?
Yeah, that would have been one of the few times I didn't have one on.
I thought you slept in it, I thought you worked out in it.
I see him walking through Long Lake in a suit. I don't.
Rides his bicycle in it, yeah.
At the pool.
At the pool, spoon, do laps.
We would have been miserable yesterday. We had the ribbon cutting for Steps to Recovery. And we were all out there in suits. And it's literally 95 degrees out. I'm dying.
No shade, right? Yeah. Where is that?
Huh?
Where was that?
It's on Trouble Creek Road. You sold the property.
Oh, yeah, okay. That's right.
On Trouble Creek, right there by, just to the west of Madison Street.
Yeah. I know exactly where you
North
mean.
side.
Yep. You did a lot of work on that land.
I worked on that for 5 years.
Did you really?
Yeah.
Yeah. That was right across from one of my grandmother's houses when I was little.
Oh.
The orange groves all over there.
Yep.
Yeah.
That's all there used to be.
Yeah, then my coach would make me run through those groves from Golf I, the old Golf I, to 54 and back. You know? And half the time I was carrying Gallagher.
I was actually confused, I went to go look at that.
He was a lazy. ATEC can do that now.
Yep, my school bus route used to come up Little Road, and remember where Lowe's is, where the big curve was?
Oh, yeah. Dead Man's Curve.
Nothing but orange trees. But
Yeah.
boy, when you drove through there in March, nothing but
Smell was
orange blossoms
unbelievable.
everywhere.
I love that smell.
Yep.
Yeah.
The same thing when you drive up 19 where Embassy Hills and Regency Park was.
Yeah.
Nothing but oranges.
Yeah.
Yes. Huh.
What was he asking?
Did we know our mics are on?
Oh, okay.
We don't have any secrets up here.
Everybody back? Terry, everybody back? Needs to be here?
We are back.
Okay,
We have the staff necessary, so.
all right. We'll bring back to order.
Good afternoon, Planning Commission, Gianna German. The next item on the agenda is item PC6. It's PDE 267596, a zoning amendment in the name of Denton Ave MPUD and Denton Ave Project LLC. It's a rezoning request from AC Agricultural District to MPUD Master Plan Unit Development District to allow for the development of 832 single-family detached units, 75,000 square feet of support commercial, and 440,000 square feet of light industrial and associated infrastructure located in northeast Pasco County, approximately 1.5 miles east of the intersection of Denton Avenue and Little Road, containing approximately 331.6 acres, presented by staff.
All right, thank you.
I just want to note before Will starts that I have an ex parte communication with the applicant, and I'll be submitting the form.
Thank you.
William Vermillion, Planning Development Economic Growth. There were some other ex partes for Planning Commission members that were also submitted to the clerk's office after the publication. This is the Denton Avenue MPUD back before the Planning Commission continued at the last Newport Ritchie hearing in April, PDE 267597. And to make this a little bit more brief, since I know there's a lot of people here to speak, I'm going to try to touch on the revisions from last Planning Commission instead of hitting you guys with the same details. The location map within the county, the request, and the acreage from the applicant remains the same, with the 832 single-family detached units, 75,000 square feet of commercial, 440,000 square feet of light industrial, and roughly 331.6 acres. This is on the south side of Denton Avenue, just north of Kitten Trail. And the county engineer, when he was briefly here for a couple minutes back during the that Euclidean rezoning, he was kind enough to remind me that Kitten Trail is being removed from the county's vision roadmap.
Right.
Here's the location map, the little tooth of the property down to Kitten Trail, the existing zoning of AC and AR, residential 6 and IL future land use, with some small pockets of Res 3 on the teeth of the property there on the southern boundary. The overall contextual map here showing the proximity to the park, showing the Bolton Avenue extension and the existing Denton Place MPUD. But more importantly, the revisions post Planning Commission in April. The first of which of these revisions was to add an enhanced pedestrian crossing at Kitten Trail. Last time the residents spoke about the difficulty there would be in getting from the pathway that the applicant is building to that, in that little pocket park in between the residential to the sidewalk that exists on the south side.
Could you put the aerial up there so that we can just see it as a reference?
Actually, it might be easier if I go to the binding concept plan.
Okay.
So that little, that southern pocket park there, that's the multi-use path, that red dotted line, the 10-foot multi-use path.
Okay.
Some of the residents last time had concerns about how you would get from the end of that to the actual infrastructure being built in Kitten Trail, adding the pedestrian crossing and flashers there on Kitten Trail for people to be able to cross.
So there's no automobile traffic going across there?
No, sir.
Okay.
None north to south from Kitten into Denton.
Right.
The second thing that happened on the southern side, and it will be reflected, it's both reflected on this plan set as well as the binding exterior landscape plan, was the southern buffer along Kitten Trail was increased from 20 feet to 40 feet along the backside of the 70-foot lots that exist on the binding concept plan in orange. This was done in particular about a year ago. There was an MPUD called the Hudson Family Trail, which had similar lot sizes and was actually within a rural character area within Pasco County. And both the Planning Commission and the Board and Planning Development Economic Growth staff found that those lots were consistent with the rural area with the inclusion of this 40-foot buffer, which is why the 40-foot number was chosen instead of the 20.
So am I understanding that this is going to be sort of heavily forested so that 40-foot buffer is difficult to see through?
Yes, sir. Yes, sir. And then the applicant does have the these illustrations of what the buffer would look like at mature stages, as well as the exterior palette. But if I move back,
Do we have a view of what the buffer will look like at the immature stage?
I believe the applicant, they had provided renderings a part of the landscaping exhibit package. I just didn't put them onto the slide to avoid 6 slides of landscaping. So I did include that in the packet to the Planning Commission where they show renderings from the townhome. I think that.
Do you have one? 'Cause
I do. It's on the. Oh, well, there's Miss Patty. She's walking up. Hopefully she can throw that up there for me. So if you go into the agenda package, my attachment that's on their binding landscape plan, if you download that and then scroll through a couple times, there's a rendering that almost kind of looks like a drone shot that I think would be easier to show. And then while Patty's doing that, the last thing we did was there was some concerns about data centers being a part of that industrial area. So data centers are now a prohibited use within the industrial area as a part of this MPUD. And of course, all of this was reflected on both the binding concept plan and the binding exterior landscape plan and the master plan. The sidewalk extension exhibit still exists as it was presented last time, with the applicant constructing the sidewalk on the northern side of Denton Avenue to facilitate pedestrian traffic to the existing Arthur Engel Park. And I'll hold there until.
Show me which file.
And before this comes up, I think I'd like to correct myself a little bit. It might not show exactly what the trees look like at their most immature, which I think was the root of your question, but it does go to show a different perspective of the buffer in terms of the elevation and renderings and scale. I'm gonna sweat through my suit up here.
Any jokes?
I don't know. I gotta have somebody bring me a napkin. Should be the last page.
Okay.
Oh, the PDF is loading tremendously. There we go.
Okay.
Oh, actually it does. It shows at installation and at maturity. The top left there at installation and then at maturity in the top right.
So that all mostly, you know, typical Florida vegetation.
It's all all Florida native is the binding landscape as a part of this MPD.
Yeah, we've seen a lot of developments that have gone in, and they have, you know, 2-foot-high plants, and, you know, that's not gonna be very helpful. So this is much better.
And the last thing on the staff presentation for me to get through is the variation requests. They're the same as the last time, but I'm going to go through these again. The first being from 901-6011 street design and dedication requirements. That is for the variation for the southern access point, which would have been to Kitten Trail. That did not change. Kitten Trail lies to the south. The applicant opted not to put any vehicular trips onto Kitten Trail and provide 2 access places to Denton Avenue, which is consistent with Table 901-3A of the Land Development Code. And then from 805-6, the restrictions on post-development wetlands and upland buffering, the applicant requests that the non-residential parcels be under single ownership. They're not required to create the mandatory association for maintenance. This comes with a recommendation of approval to the Board of County Commissioners, and I'm available for questions.
Okay. Do we have any questions for William? No?
I appreciate it. Off the hook easy.
Okay, is the applicant present?
Good afternoon again, Barbara Bullhite, 6327 Grand Boulevard for the applicant. I'm going to just briefly go through a few things that were in my prior PowerPoint because it's been a month, but try not to spend too much time on them because I know we want to talk about other things. For our application, again, we're following the comprehensive plan that the board set on this property, 832 single-family detached homes, 60, 70-foot lots along the perimeter. No 40s, no apartments, no towns, no villas, none of those things. One of the questions that came up during public comment the first time was about blending of density. We went back and checked our plan. In the Res 3 acreage, our units are 2.5 units per acre in the Res 3 area of the property. In the Res 6 acreage, we have 3.4 units per acre. And yes, Mr. Moody, we took out the industrial. I did make a mistake when I did that calculation for you last time. The current land use designations allow maximum 462 homes versus the 832 that we are requesting. That is significant because I'm asked, what are you doing? How are you being considerate? How are you working with your surroundings? That's what we're doing. This is many layered things that we did here to be very thoughtful, but one of the things was not seeking 1,462 dwelling units, even though that's what the land use would allow. We have the advanced landscaping plan. See if there's anything interesting here that Will hasn't already gone over. Changes made during neighborhood meeting. We did have neighborhood meetings. We had 4 of those, as we'll recall. After the neighborhood meetings or during them, we did the grading plan. I mean, I think when we're asking about that landscaping, what's really significant is we are required to keep along our perimeter all of the existing vegetation that exists today. And then we are requiring that we actually enhance that landscaping. Along our adjacencies, what we're required to do is a type A buffer, the most minimal buffer there is in the code, which is where the code's saying that our use and the adjacent uses are compatible with a type A buffer. But we didn't even do a type B buffer, we did a type B buffer on steroids because we're going to keep all the existing legislation. Because we did the grading plan, the client spent the money and the time to do that. He knows that he doesn't need to grade to the property line, and he can keep the grading out of these buffers and keep the natural vegetation in there, and then supplement that vegetation and plantings. We worked hard on the conditions regarding that passive park on the south side. We had a lot of requests, when we talked to our neighbors, and Robert Melson, representative of the property, actually met with them in their homes about what could go on in that park and what couldn't. They wanted it to stay natural. They wanted the vegetation to stay like it is today, and they wanted they wanted everything passive, nothing active. And so basically what we're going to do down in there is keep it natural and meander our trail down there to Kitten. We changed the Kitten trail lots. When we went into the neighborhood meetings, there were 60-foot lots. Coming out of the neighborhood meetings, again, we're trying to work, and it's a balance here between the property owners that live out there and this property's rights as well. The other thing that we did during the neighborhood meetings is the client agreed to single-story homes along the perimeter. So the question did come up about landscaping when it's put in, landscaping at maturity. Well, another thing that we did was limited to one-story homes. This is just to show where that passive park is, a lot of detail in the conditions of approval about what can and can't happen there as a result of our direct conversations with our neighbors. Nothing here that you haven't already heard, just the changes we made after neighborhood meetings. Will showed you the off-site path, again, being what we're trying to do is look at what's going on around us. That's a significant improvement, because right now the folks in Summer Chase, if they want to walk to the park, they walk along their frontage on a sidewalk, and then they walk in the dirt to get to the park. Same thing, Denton Place folks, they'll walk in the dirt until they get to our new sidewalk, and then they'll be able to pick up our sidewalk, because that project wasn't required to do anything and didn't agree to do anything. So those folks will walk in the dirt until they get to our sidewalk that we're doing. They'll take them all the way to the park. The other thing that's significant about that is that right now, anybody that's on Kitten Trail, that if they want to go to the park, there's no easy ingress and egress to that park. They'll be able to come through our trail, up our multi-use path, across Denton with an enhanced safety crossing, and to the park on a sidewalk all the way to the park. That's a significant change. Pardon me?
It's a 10-foot wide sidewalk.
Yes.
That's larger than usual, too.
Yes. So those are just things that we did, again, to be thoughtful of how we put this project together. We know there was obviously concerns about it, so those are just a highlight of what we did. After the Planning Commission, we went at it again. And specifically, what we did was, I really felt like the question in the mind of the Planning Commission members, if I could crawl in your mind, and based on what you said, was compatibility. I told you about all the things we've done in this project and how this project's been thoughtfully laid out, but I didn't give you any context. How is it compatible? Why is it compatible? How does it compare to other projects? So what we did was, we put together this consistency analysis, compatibility analysis, really looking at what does compatibility mean under the code, and looking at other projects, because I think the best you can do to determine what's compatible is see what you all have recommended as compatible, what staff has recommended as compatible, and what the board's found as compatible. So after doing that analysis of all these projects, that's what led us to what Will had explained to you, was enhancing that buffer to 40 feet along those Kitten Trail lots, where there was just a lot of comments and a lot of concern from the Kitten Trail residents about lot compatibility. So we looked at Hudson Family Trail MPUD, which, as Will explained, is in the rural character area, and said, well, if this property or our neighboring property was in the rural character area, what could we do and to be compatible? What more could we do to be compatible? And so we used that 40 feet. But in Hudson Family Trail, that 40 feet's an undisturbed buffer, so it just stays like it is. We are undisturbed and enhanced, and 40 feet. For example, when you have a type A buffer, no fence required. Our conditions require a fence. We added the Kitten Trail bike pedestrian crossing, the enhanced crossing, as requested by the Planning Commission. We updated our MPUD plan. It wasn't very clear that we have 2 functional accesses to Denton, so we just cleaned that up. We updated our enhanced landscape plan and our binding concept plan to be consistent. And staff has made the decision, and we've advocated for this for a long time, actually on behalf of all these residents, that Kitten come off Division Road. We are the ones that put Bolton through our property, not required, because today it's not a Vision Road, not required to dedicate any right-of-way for that, not required to put that bisecting our road, but we are the ones that started the Bolton should be the Vision Road. It's a more appropriate Vision Road, and we did that in our project, and the staff has apparently looked at it as well and agree that Bolton should be the Vision Road and not Kitten. Long-term impact for those residents is that it'll no longer be, when that's adopted by the board, it'll no longer be that Kitten is the future where traffic is supposed to be grow and more traffic and Vision Road standards and potentially improvements in the future. So I'm glad what we started with regard to our project is now following through with the staff removing Kitten from the Vision Road. With regard to the compatibility analysis that we did, a couple highlights of this, and I made copies of it because I thought it was just really good work, and we printed out bigger copies of the plans so you could see. But when you look at the standard of what we have to do under the code to meet the criteria to be approved and recommended for approval, we have to demonstrate that we transition appropriately to adjacent lots, or that's what the code says. We effectively shield adjacent uses in the absence of lot or use compatibility. This code actually says that even if we didn't achieve lot or use compatibility, as long as we effectively shielded adjacent uses, we get approved. But we didn't do that. We didn't look at the Denton Place and say, well, everybody recommended approval of Denton Place to our north and our west with 40-foot lots and a 15-foot type A buffer up against lots that are 5.8 acres, 2.89 acres. We didn't say, well, if that's what y'all approved as compatible, recommended approval is compatible, and the board approved, that's what we should only have to do. We're much more thoughtful than that. We were asked to be more thoughtful than that, and we have been more thoughtful than that. 40-foot buffer, enhanced buffer, as well as maintaining the existing vegetation. So we achieved use compatibility because it's residential. All this analysis shows you that we're more than compatible on a lot basis. For example, Palm Wind, MPUD, both the Planning Commission and the board found that 40-foot lots with a 10-foot code-compliant type A buffer was compatible with a 7-acre adjacent lot, a 4-acre adjacent lot, 2-acre adjacent lots. Same thing with 50-foot lots. So that's why I wanted to lay this out, because I really wanted to give you guys context of what does compatibility mean under the code, what is our requirement to demonstrate to be found compatible, and how we more than meet the requirements for compatibility under both your code and what's been approved as compatible. I think we've done a pretty good job of explaining our enhanced buffer. If you have any questions regarding that, we certainly can go through that. Where you normally would have one row of evergreen shrubs, we have two, and they're 6 feet. We plant them at 6 feet. So, just again and again and again, thoughtful presentation of how we bring this forward, brought this back to you all, and trying to make sure you had the information that you needed to make a decision today.
Do you have an aerial or anything of Hudson Family Trail?
We do. It's in here. Yeah, it's sheet number 2 on your bigger sheets.
Should we do a motion to receive and file?
Well, that would be fabulous.
Motion to receive and file.
Second. All in favor?
Aye.
Aye.
Opposed?
And then within your Hudson Family Trails, also within your consistency and now the compatibility act page.
Is it possible to put this up on the screen?
We're working on it.
What page is it, Barbara?
It's page 9 of the compatibility analysis.
The second one. Oh, I see it, yeah.
While we're waiting for that to come up, I did want to mention that we also looked at Summer Chase, which is to the north of side of Denton, just east of here. Summer Chase is approved for, it's an R4 zoning district, 60-foot lots. Were found consistent next to 12.92 acres, 6.51 acres, right in this area, because I do know some of the projects along Hudson is along Hudson, so I wanted to make sure that you could see what was approved along Denton in this area as well.
Do we have an aerial photograph of Hudson Family Trail?
Electronically, I guess you're looking for?
On the screen.
It's on the screen?
No.
No.
He's asking for it on the screen.
On the screen.
Pasco mapper.
Yeah, you can go to Pasco Mapper. How about that?
Property appraiser? No, a aerial of the property.
You just want Pasco Mapper, it sounds like.
Yeah.
Family Trail on Hudson Avenue.
Here, let me give you a parcel ID number. 27-24-17-0000-1160. That's just a lot in that subdivision, but that'll get you there.
Thank you.
Well, I'm not sure what's going on here, but the point that I'm trying to make, since we can't get a good aerial photograph, this is what the site looks like pre-developed. It's a forest, okay? Undisturbed is, I left the trees there. I didn't cut those trees down, or I'm not supposed to cut those trees down. When I look at the applicant's property, there's no forest there to save. There's a difference, right? This was supposed to be an undisturbed buffer that's a forest. There's no trees there today on the applicant's property, so it's undisturbed. What, I'm undisturbing a hayfield?
Yeah, right.
And I'm gonna plant a buffer of 2-inch diameter trees and 18-inch high bushes. And it'll take 20 or 30 years before that buffer is meaningful. Just the point I'm trying to get to.
And that's why we exceeded. We are not in the rural character area, and that's why we looked at other projects to make sure that we were exceeding what was found compatible. So again, if you look at Den Place on the north side of us, you've got 40-foot lots, 10, 15-foot type A buffer, that's it. You look at Summer Chase, north side of Denton, to our east, 60-foot lots.
I understand your
15, 20-foot buffer. So what we're doing is exceeding all of that. Palm Winds, Sackleson, they're all in there. We could have just brought you a Denton Place project and said, you know, it was because Denton Place was approved, you all found it consistent, compatible, the board found it compatible, it's been approved, it's under construction. That's the standard we have to follow, but we didn't do that.
Make it sound as if there's an automatic determination of compatibility. I would say if there was, then we would have no need to be here having a public hearing.
Well, I don't believe that to be the case. I think you have to show compatibility, but what I'm saying, based upon my 32 years of doing this, is that if you can show what's been found to be compatible, the issue that we've been talking about is lot size to lot size. The concern of our lot sizes versus our neighbors' lot sizes, existing homes. And that's what the analysis looks at, is what has been found compatible in similar situations. So to me, that is how you determine compatibility, and you do look at it, and we've analyzed it, and we've given you that information.
Okay.
I do have a question. Last time we were here, last month, and Chris Poole and Derek Montlands aren't here, but I remember when we were talking about the continuance, there was conversation on emergency access. They understood that, I won't put words in their mouth, but it might not be appropriate to have the full access on Kitten. I totally understand that, but there was some discussion on having emergency access. I was wondering if there was further discussion on that or what thinking was.
So we have not requested emergency access. It's up to, because our meetings with our neighbors, they asked us not to have any access other than bike ped. So we're followed through with that. So we have requested a variation to not have any access. Ultimately, up to the Planning Commission, what you want to recommend on that issue, on the board. I can tell you when we did Sackleson, it was the same issue. And I looked back last night to remind myself of what happened on Sackleson to Foxfire Drive, back and forth, back and forth, back and forth. The board made sure there's no access ever to Foxfire Drive from Sackleson. So that's what they did from a policy standpoint when this issue presented them very similarly in Sackleson on Foxfire to our project relative to Kitten. So we're going to follow whatever the board wants to do and whatever you all recommend only to the board. We're not going to make a change. If you recommend that, we're not going to make a change before the board because we're going to stay consistent with what we told those neighbors, because there's neighbors that aren't here today that came to those neighbor meetings. So we're going to stay consistent with what we promised those neighbors. We've had plans with access, we've had plans with emergency access, we've had plans without. So ultimately, I really see it's a policy decision for you all to make a recommendation on, for the board to make a decision on.
Personally, I think it's a better decision to have a footpath or bicycle access onto Kitten and keep them extra traffic off. I like the fact that you moved the Vision Road north away from Kitten, because I think Kitten should remain more of a rural road. And I think that would be important if I lived in that area. The other thing I think we need to remember is that this property was actually zoned for a lot more units than you're asking for.
The land use, yes, the land use, correct.
Land use. So, and I know we're not required to give the maximum, but we're not given the maximum. But we are required to take into account people's property ownership rights. And so, I think this is a much better plan than you came with last time. And I think it takes away some of the concerns that I would have if I lived on Kitten Trail. And that's what I try to do. I try to put myself in their situation. I also appreciate the fact that you're not going to have any two-story homes on the perimeter. So you don't feel like there's somebody looking down on the home adjacent to your development. And that's come up a number of times in other applications. And I thought that was a good consideration. So I'm pleased sort of with what you've come up with.
Thank you. Well, if you have any more questions, I'm happy to answer them. If not, we'll let the public speak and come back.
I think my question might be for staff. So I appreciate you putting the flashers on the south, and I think you put it on the north as well.
That's correct.
I like that you did on both. But my question for staff, and I know this is how it was done in other MPUDs, and I think maybe in my mind, when I go to look for those flashers, I immediately go to the conditions of approval, and they're on the master plan, but they're not necessarily on the binding plan. So I think my question might be best for Patrick Detter, but he's not here. I just want to make sure that his team knows to look at those master plans or binding plans to know, saying, hey, there's supposed to be flashers here when it comes through site plan review. I think him and his team know that, and I think they're trained to look out for that, but.
David Engel, Planning and Economic Development Director. We do more than that. We have a tracking sheet on all our MPUDs now that are shared with all stakeholders that do subsequent plan review or permitting. So when an MPD is approved, we have a tracking document that Patrick's team receives with a checklist with all the obligations all laid out.
Oh,
Thank you.
perfect.
All right, thank you.
Okay, yeah, are there any other questions for Hyde? No? Okay. All right, you wanna let me know who signed up to speak?
Mr. Chair, the first individual I have for public comment is a Mr. Ken Howard, and after that it'll be Martin D.
Okay. If the second person would like to come up closer to be ready, that's fine.
Name's Ken Howard, address 11117 Kitten Trail, Hudson. My first concern is road safety. Denton Avenue traffic fatality since 2019 is 7. Kitten Trail has 9 fatalities from Hicks Road to Coyote Road. Long-term residents say there's more. Backup traffic is most likely to occur on Denton Avenue with the addition of 1,200 plus cars to it daily. The overflow will definitely come on to Kitten Trail, an already busy road with school traffic. Of the 9 fatalities on Kitten Trail, let's not forget the school bus accident on Kitten where there were students that were in injuries in 2019. As discussed, open Bolton Avenue for overflow, this will take most likely years from now. Traffic will be a mess and it will only be a small relief to a congested nightmare. We are looking at a small gesture of putting in crosswalk to propose sidewalks. Some white paint on a road with flashing light is not going to make anyone any safer. Family Trail is not affiliated with Hudson Family Trails. It is an access road from landlocked properties, actually owned by an elderly lady in Tennessee, 24-foot wide, 419 yards long. No buffer for approximately 1,000 feet. Family Trail, 3 properties on the east of the trail. On the north of the development, only 2 properties, for a total of 5 residents affected. Blackwell on the north is 6 properties, west 7 properties, east 3 properties, all various acres, and on the south 4 properties. All boundaries have heavy forest with no residents on 4 properties, with a total of 20 properties affected. Summer Chase on the south is Denton Avenue. East is light 8 properties with Coyote Road separating them with a small buffer. North is 4 properties, west of Pasco Park system, a total of 12 properties, all various acreage. Shackle and Hudson Park. Buffer on the north of Hudson Park, a buffer on the north is Hudson Avenue. East is Peachtree Road, a subdivision in progress. South is 5 lots, various acres with 4 lots of 8 acres, a total of 9 residential properties. They also go on with, comparing Palm Winds and Denton Place and Sagebrush, which is 804 units are proposed. West is 5 properties with a 1,312 foot of Pasco land. North is 11 properties plus a mobile home park, and the east is 5 properties for a total of 17 properties affected. Denton Avenue project west is 874 yards of Pasco land, 11 residential acres. South is 14 residential acres. East is 10 residential acres, plus undeveloped land of 39 acres. The difference is 35 residential properties affected, all various acres, unlike Summer Chase of 12, Blackwell of 20, Family Trail of 5, Palm Winds of 16, Denton Place Sagebrush of 17. The Shackleton of 9 residential acres. The comparison of buffers with these properties is a long shot from what Kitten Trail properties have to offer. The commissioner who suggested 1 acre tracts for Denton Avenue project has seen the value of the homes affected by the project with overdevelopment and housing with small 70-foot wide lots abutted to acreage, and in his words, estate-style properties. With this, I still feel the project should be turned down. The comparison properties with buffer are deceiving to compare with Denton Avenue project and surrounding properties. This is not usual and customary to existing properties. Thank you.
Okay. Thank you. I was able to give you extra time because I heard the buzzer go off. I was trying to be considerate of your presentation, but I'm going to have to try to keep everybody to their 3 minutes, so.
I'll go shorter.
Thank you very much.
After Mr. after Mr. Martin D., we have Mr. William Roberts.
Good afternoon. My name is Martin Dullabach. I live at 15432 Dennis Drive, Hudson, Florida, corner of Bolton and Dennis. The problem is I got with these people, not that I disrespect them, but they're looking for everybody, to accommodate everybody down the road. What about the people surrounding that property? You're taking big pieces of property and throwing pebbles in the middle of it. And I'm sorry, we call us stones, but the pebbles in the middle. That's what they're doing. I'm sorry about the property half mile down the road where there's barely anybody, where you got less people coming in to eject. I can't understand it. Same thing like he was mentioning, which I agree 100%. You guys offered something about 1 acre per house. Not only did they ignore you, they didn't say, hey, we're going to decline this or accept this or think about this. They flat out ignored it. And that's all I got to say. Thank you.
Okay, thank you.
After Mr. William Roberts, we have Miss Janet Carlisle.
Good afternoon, members of the board and staff. My name is Bill Roberts. I reside at 12,700 Ithaca Avenue, Hudson, 34667. I'm giving sworn testimony, and thank you for this opportunity to speak. This is my first time ever doing this, so I hope you give me a little latitude. I don't have all the technical stuff that people have.
You're welcome to be here.
I am here to oppose this zoning change in rural Pasco. Rural Pasco is disappearing piece by piece. Every rezoning may seem small on its own, but together they permanently transform agricultural and open land into dense urban development. Once the rural character is gone, it cannot be restored. Residents bought homes, farms, and property in these rural areas with the understanding that the county intended to preserve lower density development, protect natural resources, and maintain compatibility with existing communities. This proposal would increase traffic on roads that are already strained, especially during evacuations, school hours, and peak commuting times. Infrastructure in many rural parts of Pasco simply has not kept pace with growth. Approving more intensive development before roads, drainage, schools, and emergency services are adequate burdens existing residents and taxpayers. There are also environmental concerns. Rural lands provide wildlife habitat, groundwater recharge, flood storage, and tree canopy that help reduce heat and stormwater impacts. Overdevelopment increases runoff and flooding risks, especially in a county already dealing with drainage problems and extreme weather events. In my opinion, the highest and best use of this tract is to preserve low density. To be clear, I am not opposed to growth. I know Pasco County will continue to grow. My concern is density. Growth should occur where infrastructure already exists and where the future land use map and zoning were designed to accommodate it. Smart growth means respecting established planning principles instead of continually pushing suburban density further into rural communities. Developers often promise buffers, landscaping, and traffic improvements, but those measures do not replace the loss of rural character, open space, quiet, and quality of life that current residents value. And once rezoning is approved, future boards have little ability to reverse the long-term consequences. The projects on the north side of Denton have already changed the character of the community by clear scraping those forests and using massive loads of fill. It's awful. As a native son of Florida, I have watched the growth in this state for a very long time. The land where I met Neil Armstrong while dove hunting is now tract housing. I asked the commission to protect rural Pasco County and deny this zoning change to preserve the character of the community. Again, thank you.
Thank you very much for coming.
After Miss Janet Carlisle, we have Karen Roberts.
Good afternoon.
My name's Janet Carlisle, 16108 Pickett Lane, Hudson. I had a couple of key points. First of all, Summer Chase, in my book, is not consistent with a rural area. Everybody out here, they all moved out into the country. They wanted acreage, they wanted land, they wanted peace, they wanted quiet. We are not going to have that if they're going to open it up and just let all these small property housing go in, okay? We have already problems with wildlife movement. The more that you're developing out there, they've already put sagebrush in. We're already seeing an increase in coyotes on the property, rattlesnakes. I don't expect to put my dog outside and have to worry about that. Policing, it's pretty much null and void out there. We can't even get police out there to run traffic control when you got speeders. You hear the crotch rockets flying down Denton Avenue every morning and every evening. And also my other concern is if when we are in flooding and rainy seasons, that area that they're proposing to put all these homes does flood, and it does flood over top of Denton Avenue. So I'm assuming that drainage would have to be addressed. With that point, if they build up the land, how does that change all of our flood zones? Are they going to make that so now all of a sudden, with those of us that are not in a flood zone are now going to be flooded every time we get a storm for runoff? Our water quality, we're all on wells. How is that all going to affect us? There's just a lot of things that we all want to have a nice, quiet, peaceful area to live. That's why we moved out to these areas. So with that, I'm basically against all of this. I just want it to be country. I want it to be and stay rural. Thank you.
Thank you.
After Ms. Karen Roberts is Ms. Sue Bolton.
Good afternoon. Good afternoon, Board. My name is Karen Roberts. I'm very humbled and also kind of disappointed to have to be here today. I live next door to my sister. I live at 16126 Pickett Lane in Hudson, 34667. And I have lived out there for 20 years. I'm on an acreage. I'm looking at the maps that they're showing us as far as where Bolton is going to take this brunt of all of this extra traffic. They don't even connect. Bolton and Denton and Kitten Trail, they don't connect. So I don't see how that's going to even happen. Denton Avenue right now might as well be I-75. We have so much traffic, big, huge trucks. I have almost gotten killed. I cannot tell you how many times trying to make a left-hand turn, crossing oncoming traffic when there's nobody coming, but I have to worry about somebody passing 6 cars behind me, coming into my lane as I am trying to cross into where I live. I am in agreement with Mr. Roberts, who's not a relation, and everything that my sister has said, Ms. Carlisle. I can't stress enough how we're taking away little by little our peace of mind, our structured values that we came here in Pasco County to live for and live with. I beg you, please do not pass this ordinance for these homes to go in here. We have eagles living over on that property. We have gopher turtles, all kinds of other types of animals. We also have a big, huge spring in which the cows used to drink out of there when they lived there. They did reforestation. It all used to be pine trees. The people that lived there did that. And then after years and years and years, they finally cut them down and reseeded. Some of them did grow back, but not the majority. I think they just didn't water it properly. But I just beg you, please do not pass this. Thank you.
Yeah.
After Ms. Sue Bolton is Ms. Deborah V.
My name is Sue Bolton. I live at 10923 Kitten Trail. My biggest concerns are flooding. I am very low. In fact, Mr. Seminole stated the last time that we had this meeting that I was very low. Last week, when we had rain, I had lakefront property pretty much. I'm concerned about runoff as far as waters because I have a well. Another big concern of mine is the gopher tortoises. I have 3 acres and I have 3 turtles that live on my land. And I have possums. I have the red-headed woodpeckers on my property. Where are all these going to go when all of a sudden we have more traffic, which is another complaint because, like the lady before me just said, I go to make a left turn into my driveway, which I'm 1 lot past Dennis Drive. I go to make a left-hand turn, which I've turned my turn signal on at Dennis Drive, and I have cars passing me going between my mailbox and my fence, and nothing is done about the traffic out there. One day this summer, I saw a bunch of kids running down Kitten Trail. I knew that it was the children from the high school that were out running track. It's always been that way. They always ran down Kitten Trail. But the traffic has gotten so bad. I called a friend of mine that's a principal at one of the schools right there. And I said, Danny, you've got to get these kids off of this road. They're, we've already had a number of fatalities. These kids are going to get hurt. So she called the high school. She's a principal at the middle school. She called the high school, and they immediately went out and got them all. I mean, so I guess those are my biggest concerns. And I appreciate you guys listening to us. Thank you.
Thank you very much.
After Miss Deborah V is a Miss Tracy Love.
And who's next after that?
Deborah B.
Deborah Lee?
Deborah V.
V? And who's next after Deborah?
Tracy Love after Deborah V. So if Tracy Love, or excuse me, if Deborah is not here, Tracy Love.
And who's after Tracy?
There's more people that aren't signed up.
Oh.
Yeah. I'm actually Tracy Lowe. And I reside at 10408 Kitten Trail. First, I'd like to thank the county staff for always being available, this commission for your time and consideration. We are very grateful for a reduction in density from 1,614 residences to 832 residences. However, we also feel it's important to acknowledge that this reduction was not solely the result of voluntary actions by the developer. In May of 2022, the Tampa Bay Regional Planning Council recommended halting the rapid conversion of commercial and industrial land to residential neighborhoods. As a result, the Denton Avenue MPUD abandoned its comprehensive plan amendment change and removed the proposed multifamily dwelling units from the project. That being said, we are deeply disappointed that the Denton Avenue MPUD application, which was continued on April 16, 2026, failed to meaningfully address concerns raised both by this commission and the surrounding community. Specifically, we are disappointed about the applicant chose to not revise the perimeter lot sizes to the 1-acre lots that were strongly encouraged during the previous hearing, leaving the project at a density of 3.4 dwelling units per acre. This raises an important question. Why would the applicant choose to disregard the recommendations and guidance provided by this commission? As our community expressed not only in April 2026 hearing, but also throughout 2022 and during multiple neighborhood meetings, this development, even the proposed revisions, remain incompatible with the surrounding area and the existing rural character of our community. In addition, our area already faces an overabundance of housing. Ms. Wilhite herself illustrates this in the supplemental consistency analysis submitted on May 14, 2026. Our residents have already witnessed firsthand the impact rapid development has had on nearby rural areas. All you have to do is drive down Hudson Avenue to see the damage that unchecked growth has caused to the rural character of this community. The requested rezoning change does not reflect compatibility with the surrounding land uses, nor does it demonstrate that the applicant truly listened to the concerns of the neighboring residents or the recommendations made by this commission. The refusal to incorporate larger perimeter lots shows a lack of willingness to compromise or responsibly transition this project into the existing community. For these reasons, I respectfully ask that you deny this application. Thank you very much for your time and consideration.
Okay, thank you.
Up next is a Mr. Tim V, and after that is Nola Leclerc.
Good afternoon, Board. Thank you for this time and this opportunity. My name is Tim Vandenberg. I live on 11595 Kitten Trail in Hudson, Florida. We have a little over 800 feet of property line sharing on the south eastern spur of this land development proposed, we also have about just under 12 acres of property, one of the largest that's affected by the development. In the last meeting, as others said, the exterior lots were proposed to be larger and blend more with the rural characteristics of the surrounding area. We are asking for the 1 acre lots that were proposed by the board and sizes to match the community and surrounding as a minimum. Many, including ourselves, have large type animals, including horses, donkeys, goats, and maintain that rural lifestyle around this community. The impact of the surrounding infrastructure, including roads, schools, utility, emergency services, and more will be greatly impacted. We appreciate the efforts to increase the buffers and the natural barriers, but wanted to emphasize maintaining this rural type of community in a way in a life that has been there for decades, if not longer. We also wanted to verify that only single-story homes would be built on both the south shared property line and the north sides of that spur. I understand that they're going to be on the property line, but I wanted to make sure it was also on the north side of that spur. Due to our elevated position and views, having a 2-story residence in these areas would remove the privacy of the affected homeowners, and that would be for many years until that buffer matures naturally, which could be 5 to 20 years, depending on the type of buffer. Thank you for your time and attention in hearing our community and concerns, and I'm opposed to the current proposed plan. Thank you very much.
Thank you.
The last individual signed up to speak is a Miss Nola Leclerc.
Good afternoon, Commissioners. I live at 15700 Mattis Road. I'm directly across the street on a dirt road from this development. I have a 10-acre equine estate, and I breed Palomino Foundation quarter horses. I don't think
Before you go any further, could you just give us your name for the record, because we're recording and all.
Nola Leclerc.
Thank you, Nola.
I'm really surprised that something like this would be going in our little piece of heaven in this small corner of Pasco County. The reason I moved up here 20 years ago was it was close to the beach, the hospitals, the Horsemen's Association, so my kids could have horses. The same with the other neighbors. All of the people on my street have 10-acre properties, and no one has taken us into consideration. And here we are. There's the development in my front yard, and they give us 20 feet for a buffer. They're putting in all these houses in this beautiful agricultural large lot community all the way down Denton. They're 2 acres, acre and a half properties. We have that one little one over by the ballpark. I don't know how that was passed. But I'm just saying, don't ruin this little piece of heaven that Pasco has left in this small corner of the community. Thank you.
Okay, thank you very much. All All right, is that anybody else?
There is nobody else signed up to speak, Mr. Chair.
Okay, is there anybody that wants to speak that hasn't signed up to speak? Okay, if you please come forward and give us your name, your address, and have you been sworn?
No, sir, I haven't been sworn in yet.
Okay, let's get you sworn.
Do you swear or affirm the testimony you're about to give is the truth, so help you God?
Yes, ma'am. My name is Matthew Carruthers. My family resides at 12224 Kitten Trail. I've heard from a lot of folks here that have been here a long time, some that have been here for a short period of time. I'm a generational resident. My children will be the 4th generation on that property. I am a 6th generation Floridian. My children will be 7th. We have sat by, me specifically, and my brothers, and watched my parents and my grandparents struggle with their day-to-day activities living on Kitten Trail. The roads were lime rock, they were holes. Other residents in the area would have to come out and pull each other out from the roadways and whatnot. There was no real pavement past Cobra Way coming back down that way, and we just dealt with it. Whenever the county decided to put in the refuse center and put in the dump and whatnot, all of a sudden Hudson Avenue went through and Hudson Avenue got paved. Kitten Trail got paved the rest of the way down. And with that pavement came the heavy haul trucks, trash trucks, dump trucks, rock trucks, you name it, all coming down. We dealt with that as well. Dealt with the new neighbors moving in, didn't like how the area was set up, consistently having to deal with code enforcement coming out, cleaning up, doing whatever we had to do. We dealt with it. Now we have this big development knocking on our back door. We have all of these homes that want to be shoved down our throats, and like many of us have already stated, we have horses, we have chickens, we have goats, we have large parcels of property that we contain all this on. This what you're proposing now is, or what they're proposing now, this doesn't fit the criteria by any means. I'm 45 years old. I've lived for 45 years on that road. I have watched everything come down that road. And for once, I'm asking and coming on behalf of my family to ask, don't do this to us. Don't make us have to swallow this. We've endured a lot on that road. We have made do with what was given to us on that road, but please don't push this down our throat. Thank you.
Thank you.
Good afternoon. I have not been sworn in either.
Okay, let's get you sworn.
Do you swear or affirm the testimony you're about to give is the truth, so help you God?
Yes, absolutely.
Your name, please?
My name is Skylar Talley.
And
I
your
live at
address?
10929 Kitten Trail. I'm right at the southwest corner of this development. First thing I want to say that I noticed actually today, Pasco County, open spaces, vibrant places. It seems like we're taking away a really large open space and crowding it significantly. I mean, this is one of many. It's not just one. We were mentioned, there was, what, 6 other developments that this was compared with? And those are all within a few miles of my house. Seems like we're gonna have to probably change that soon because the amount of open spaces are disappearing. I mean, vibrant places, maybe. Seems like a lot of nice colors that they're putting in for all the palettes for these developments that are coming in, but not really having open spaces. Hold on. Another thing I wanted to mention that I heard them speaking about was the compatibility with similar developments and situations. But the development scale and the proportion in comparison to these other developments and what they're doing to try and, or what they've been approved for is just night and day. I mean, the near-die developments pale in comparison. They're overshadowed by the magnitude of the impact that this one is going to have on our community. Last time my comments were about the impact of the educational system because I believe everyone here would agree that as the current generation, we need to be good stewards and preserve what we have in our community for the future generations to come. This is going to change the community and this entire area. It's going to change, all the developments that are going in are already changing it, but this impact is going to turn it into a suburban area. It is going to change it from what it is now. And most likely, the people who have been in this community for a long period of time are going to see the effects of these new neighbors that aren't trying to move into a rural area, that aren't trying to go and have horses, have goats, have chickens, shoot their guns in their yards, which they have the right to do so. And it's going to cause a lot of issues that as the time comes. And the other big thing to me is the water supply. I understand that they're going to be having new pipes laid in. Nobody's going to be on wells. Well, last time that happened in nearby communities by us, the county came in and everybody had to sign off on taking county water and paying another bill and not having their well anymore. We mentioned last time about where's the water coming from when we were in a severe drought. Well, the water's coming from far, far, far away from our lots. So we're going to be piping all of that to where we're at. They're going to try and take us off our well water, which is actually helping with the droughts because we're taking from an area that has trees, has canopy, has grass, has the things to be able to supplement that water supply instead of trying to take it from an area that we've piped down to and go through more drought issues. As I'm being from California, I've seen that a lot. Thank you so much for your time.
All right, thank you. So, is there anyone else?
I'm not sworn in either.
Should we maybe ask if there's anybody else who think they may provide public comment also would like to swear in? I mean, even if you're thinking about it, you may choose not to. You might want to stand and swear in just in case.
Do you swear or affirm the testimony you're about to give is the truth, so help you God?
Yes, of course. My name is Lori O'Malley. I live at 10325 Kitten Trail, Hudson. I've lived in Pasco County my whole life. I moved from Newport Richey to Hudson because of the rural factor and that I could have livestock. The county must grow. The development has to happen to some degree, but at what cost? And this young lady has gone to a great deal of time and energy and education to tell us how compatible this is going to be. Well, it's not going to be compatible. We're all rural. We're all got livestock. We all got a different lifestyle than where she lives on Grand Boulevard. We also don't have the millions of dollars that these people have to give the county. We're just the people that live there, have raised our families, and enjoy the open area. All the construction has changed, like so many people have said. Yes, there is an animal issue. Yes, there is a water issue. We all have wells. We're all concerned about it. But I have to say also that I'm pretty cynical about the whole thing because this is going to happen. They have millions. Y'all aren't going to just say, okay, it's rural, these people have lived there. I've lived on Kitten Trail for 40 years. And I appreciate you guys' time. I appreciate y'all listening so you do know how we feel, even though I feel like it isn't going to make much difference. But thank you for your time this afternoon.
Thank you. Is there anyone else? If not, wait a minute, Barbara.
Barbara, wait.
And you need to be sworn?
No, I've been sworn. My name's Ann Atkinson. I live at 11439 Kitten Trail. I share 279 feet of my rear property
with the project. We've only been here for 3 years, but we've grown to love it. We moved here for the same reasons everybody else did. To be rural, to be in the country, to have animals. I have goats. My neighbors have a horse and a donkey. We all have dogs. I have chickens. It's great. I love it. However, when you put up these homes behind us, these people who come to buy these homes, when you walk in that neighborhood and you're house shopping, it seems suburban. It doesn't seem rural. Well, they're going to get a surprise if they buy on the perimeter in the back. They're going to hear gunshots. They're going to smell horses and donkeys and goats. They're going to hear roosters when they want to sleep in. So guess where it's going to happen? They're going to call the sheriff and go, hey. Then they're going to come talk to us. And that's not right. It's real hard to back suburban up to rural. While I appreciate the 40-foot buffer, I'm really glad about that. These 70-foot lots, that can't happen. There'll be 4 homes behind me. There'd be 12 to my neighbor to the east, and then 3 on the next 5 lots to my west. This isn't compatible. It does not mesh. The family, the Hudson Family Trail, that only affects like 6 people. This affects a lot of people. The buffer that's on the Hudson Family Trail, that's thick woods. They never had to touch it. That is a natural buffer. These little trees, even if 6 feet high, they're not going to grow fast. I don't know what else to say at this point. I'm against it, but thank you for your time.
Thank you for coming.
Good afternoon. Tim Lowe, 10408 Kitten Trail, Hudson, Florida. I have been sworn. Chair, Commission, thank you for your time. I believe the real question today is compatibility. It's kind of where we left off with our meeting in April. We had over 17 people come forward, as we did today, to speak in opposition to this project, mainly because of lack of compatibility. That primary reason being density. We're talking about 331 acres of a project with a large amount of homes, industrial, residential. And from the last meeting, the only thing that changed was a little bit of modified buffer to the southern end, contrary to what the board had requested, contrary to what the neighbors had requested. They also came forward with some comparison projects in the area. 6 projects, I believe. 5 of them that have already been talked about, how they do not compare to this project, were the Family Trail Project, 38 acres, Blackwell, 107 acres, Palm Wind, 116, Sackleson, 34 acres, Summer Chase, 39 acres. Summer Chase, I think, wasn't that approved like in 2006? Quite a while ago. Not really a good comparison. My point here is those 5 projects all combined will fit on the Denton Avenue project within a couple acres, plus or minus. Completely different scale. So in my opinion, that's not comparable. The one that would be objectively compared would be Denton Place, a little bit over a quarter mile away down on Denton Avenue. It's fairly equal in size, 306 acres. 800 units. Scale-wise, very, very similar. However, the surrounding property is not. To the north, you have a mobile home park. To the south, you have Denton Avenue. And then the eastern property there is Pasco Facilities Management. And then on the western side, you've got some lots, but also Pasco County right-of-way. And then, you've got towards the northern portion of that western lot, you have some 50 to 60 foot wide lots that border that western property line. Majority of it's Pasco County right away, and then 5 rural lots that are affected. So the big takeaway between those properties or projects and this one is you don't have the amount of people that are coming forward in opposition the amount of rural property owners that are affected by it. So when we had that meeting last month, I think we communicated that quite well, and I just want to reiterate that. So again, thank you for listening. Thank you for your time.
All right, thank you very much. Okay, does that do it for from the audience? If so, would the applicant come back up and maybe answer some of those questions, concerns?
Just before Barbara speaks, can we just confirm there's nobody online, staff? We have no virtual commenters on this one, right? Gianna? There's nobody signed up to speak on this one virtually?
Correct, there is nobody online.
Okay, thank you.
Yeah, okay, so, Ms. White, we had some questions about drainage, some questions about where the water's coming from, discussion about the Bolton connection, about wildlife surveys maybe, and where you're gonna put the one-story buildings. I think those were some of the major concerns.
Okay. So a couple things. I'll have Joseph and he'll come up and talk drainage. We had 4 neighborhood meetings, so he's talked drainage a lot. He did the grading plan in between our 3rd and 4th meetings, so he's very familiar with the grading out there, the drainage out there, what he needs to do to address the water impact from this project. With regard to wells, and I'm sure Mr. Seminole will, in the concern of one of the neighbors that they'll have to give up their well, the water supply is coming from Central Water and Sewer, which is on Denton Avenue at this project. The public infrastructure is sitting at the front door of this project. The comp plan says where you have public water and sewer, Central Water and Sewer, minimum density is 3 units per acre. And it says that for a reason. It's so that the investment in public infrastructure is not wasted by the fact that there's a desire to have lower density, because the decision to put in Central Water and Sewer is based upon future land use plans. The future land use on this property is Res 6. So I understand the question and the concern about losing wells, but there's no pipes coming a long way. They're sitting at the door. The Central Water and Sewer is sitting there. The minimum density per the comp plan is supposed to be 3 units per acre. I did the calculation because I'm like, oh my goodness, we keep going around in circles with regard to all the density. What is our density? So I did it based upon Joe Semino's plans. We have 251.8 developable acres divided by 832 units is 3.026. That is our density. The Res 6 portion is 3.4. The Res 3 portion is 2.5. The neighbors that talked about the north versus the south spur, that's in the Res 3 land use, where our density will be 2.5 units per acre. And yes, we'll have 1-story homes on that spur, all the way around that spur. Bolton, I know we talk a lot of technical things here. Vision Road, it's the fact that the Vision Road network and what the future network is, and the county's improvements to the roadway network in the future, and you guys know this, and what that is intended to be. Where does the county want to put improvements to build out their network for county build out? And they did want to do it on Kitten, but the county's changed it to Bolton, so I just wanted to explain that a little bit further. Let me just, obviously the conversation regarding rural versus urban, I took notes when Mr. Roberts spoke. We have to balance here, just because we have the folks that have their rural homes and their lives versus this property that has rights to. It's a Res 6 land use. It's not in a rural protected area. Our neighbors to the south are in a rural protected area. They're in a Res 3 area. So I think it's important to understand that I've tried to achieve that balance and respected the fact that they have their homes and they're rural. But I also need to understand that we also have property rights and try to achieve a balance between where you have Central Water and Sewer, where we're not doing the density based upon the land use. I noticed, you said make sure that you have density where infrastructure exists and comprehensive land use plans provides. That's exactly what we have here. We have the infrastructure here. We've done the traffic studies pursuant to the code. We meet all the requirements with regard to our traffic on Denton. We'll actually, eventually, our project will put in a traffic light, which will actually slow down and make people stop, which I think that will be good. I'll have Joe come up here in 1 second so he can talk about flooding and animals. And Mrs. Lowe said why we changed our project in 2022. It wasn't based upon TVRPC. It was based upon listening to their comments. The pages of documents that you have in your record with all of the comments from 2022, we read every one of them. When Mr. Melsom came on board to represent the property owner, he read every one of them. So it wasn't some TVRPC study. It was actually listening to the neighbors. We approached this, the same issue came up in Sackleson on Foxfire near Colony, east of Peachtree on the south side of Hudson, with regard to, we live a rural lifestyle, we have animals, we have, your residents won't know. And what the Board of County Commissioners asked us to do was write a condition, a rural disclosure condition. And I have written that language, and we can certainly add that, like the board asked us to add for Sackleson, which had the similar concerns. We can certainly add that disclosure into this project if you want to. I can hand it out, but we do have a condition so that all of our property owners across our project will know, where they're choosing to live.
Can you read that disclosure?
Sure. I can actually pass it out to you. I made copies.
Motion to receive and file.
Second.
All in favor?
I can pass it down.
The applicant developer shall provide written disclosure to all units within the Denton Avenue MPUD that they are purchasing a residence in proximity to properly currently zoned AR and AC, which allows commercial farming and agricultural activities, general farming pursuits, and maintaining livestock protected by the Florida Right to Farm Act, Florida Statute Section 823.14. The applicant developer shall provide a copy of the written disclosure to the county concurrent with the associated record plat. This disclosure obligation will cease if all the lands within a half mile of the MPUD have been rezoned to a zoning district that does not allow for commercial farming and agricultural activities, general farming pursuits, and maintaining livestock. The reason why that last sentence was in there, because like this area, that we have Res 6 and Res 3, that area also had a different future land use from how it was currently developed. So if the property ultimately in the area ultimately develops differently, that's what that was written for. But we certainly can add that condition. The board asked for that in approving Sackleson. Did I catch everything, Mr. Chairman?
I think the only thing you didn't talk about were the wildlife surveys.
I will have Mr. Semino come up and talk about wildlife and drainage.
Okay.
And wells and water and.
Before you do that,
Mhm.
one of the questions the public asked, which I think would be reasonable to answer, is the suggestion was made to come back with some 1-acre lots, so why can't we do that?
So we were asked the same question in our neighborhood meetings, and the client did evaluate that. They told the residents, the same residents asking for it now, we're at our neighborhood meetings, and he did evaluate that and the feasibility of that. I can have him come up and answer it if you'd like.
Okay.
Best person to do it, to talk about it, is the person that actually looked into it, so I'd be happy to do that.
Okay, great.
But we've got Joe at the moment, so let's let Joe.
Yeah, that's fine.
Let's let Joe come up and talk Joe stuff. Thank you.
All right. Hello again, everyone. We'll start with drainage. This is, a lot of times when we develop property, we have water.
Sorry, could you just, for the record, your name?
Yeah, Joe Semino, WRA Engineering, 12363 Hampton Park Drive, Tampa, Florida, 33624. A lot of projects we do, we have water shedding off the site into neighboring communities, into neighboring waterways, and we have to make sure we're maintaining rate and volume leaving the site. This is a rare one where all the surrounding water is coming at us. So we've painstakingly done a pretty elaborate grading plan with a lot of detail, much more than we would do at this level of planning, to make sure that the critical locations where water is entering our site, there's probably about a half a dozen critical locations. We have allocated room for drainage inlet intakes and easements to get water to our very, very large ponds that we've incorporated into this plan that are sized to hold the 100-year storm event without even considering infiltration, which will absolutely happen out here. Ms. Bolton's concerned. She's absolutely got an issue in her yard. She's south and west of our site. We don't really share the same watershed, but I would be more than happy to, volunteer my time to talk to her and see what can be done on her property. But her water doesn't come at us, and our water doesn't go at her. From a wildlife standpoint, this application itself required a full comprehensive threatened and endangered species survey. If this proceeds, when we go to construction plan review, whether there's one phase of construction or it's broken up into multiple, each application will require a new threatened and endangered species report. And then even once, and if it goes that far, even if that's approved, prior to construction, we're required to do another threatened and endangered species survey no less than 90 days ahead of construction to just see what the final result is. And any threatened and endangered species have to be accommodated. In some cases, that means changing construction schedule, adding additional buffers. With gopher tortoises, it means relocating them to a mitigation site. So there's basically 3 levels of checks on the threatened and endangered species leading up to construction to make sure they are not bulldozed over. That's not a thing that happens anymore.
So, okay. So have you found a lot of wildlife on that site?
Yes, the initial MPUD found 100 gopher tortoises, which is pretty standard for a site that size. The good thing is, just looking at the map, the highest concentration is along the southern property line and the park area to the south that we're actually preserving. So that's actually where the highest density is.
Great. Any questions? Okay, thanks, Joe.
Grading, landscaping, trees along the southern boundary.
Would you like me to go into that? Sure, yes. We were also looking at the aerial maps in Google Earth 3D, which actually allows you to see more 3D versions of trees. And yes, there's not a forest like those other pictures you saw on the southern half of the property. However, there is a tree line along the southern boundary. It's absolutely in what would normally be the grading limits of a normal project. No developer wants to remove trees if they don't have to, but in many cases, you have to raise the site, grade the land, and you end up removing those trees and planting a new buffer. The painstaking efforts we took on our grading plan, one of the questions or one of the challenges that I was tasked with was, can we not touch any trees along the southern property line with our grading plan? And we made it work. There's a lot of ups and downs. I didn't think it would, but we're committed to preserving all the existing vegetation along the southern property line, and there is absolutely a mature tree line along most of that boundary that would be preserved because of the grading. And I'm happy to answer any other questions.
Anything from up here? No? Thank you, Joe.
All right, thank you.
Good afternoon. My name is Robert Melsom, and I am developing the property on behalf of New Strategy Holdings. So I guess the question was, how do we define the width of the lots that will be in this community? And
That wasn't the question.
what was the question?
The question was, when we had our last hearing, there was some suggestion that we'd probably find this property more compatible if there were some 1-acre lots to help make a transition to surrounding properties. So what I'm asking is, how come, or what is the problem with providing some 1-acre lots?
Well, if you want to refer to it as what is the problem, know if I'm really going to answer the question that way, but I'm going to tell you how we define the lot widths that we have. You know, again, as what we are is we're a community developer, and we develop communities and we sell our lots to home builders. So the way that we defined the maximum width of a lot that would be on this property was by speaking to the group of home builders that we typically do work with. And when I spoke to them, you know, had, you know, many conversations with, you know, marketing people with the home builders and division presidents and operating executives, they said the maximum size lot that we could, we would be interested in purchasing on this property in this market is a 70-foot wide lot. So what we decided to do was we decided to, you know, place the 70-foot lots along the southern portion of the property, and we're really seeing this more like an enclave. And I'm doing another community with 70-foot lots, and those homes are selling for $700,000-800,000. So that is why we have 70-foot lots. It's a market-driven response.
Any comment?
No, just wanted to know.
Any other questions the team can answer? So I would just close in just saying that land use does matter. It matters both to the residents and it matters to my client. The comprehensive plan was set by the county at 6 units per acre. We've looked at what's around us. We've made all the changes. We've really tried to come to a reasonable balance. Not a balance that ultimately the client wanted more. We had plans for more. We took those plans and changed them. After in 2022, it is now 2026. 2022, we took those plans and we changed them, listening to the neighbors. Then we continued to listen. We did 4 more neighborhood meetings, and then we listened more at Planning Commission. So in the end of the day, you have to strike a balance between the properties. And it's not in a protected rural area, but we've tried to balance it as though it was. And that's what I've tried to do. I've tried to provide a benefit where we can with off-site improvements, on-site improvements. And so it's been very thoughtful. It's been a journey to get here. We're not changing the land use. We are respecting the land use. And I know it's a hard decision for you all, but I think we've done what we can and what we need to do, and by the way, what we're required to do, because there's actually a comp plan and a code to follow here that says what we have to do to be able to be approved. And we ultimately have met those and exceeded those time after time. So with that, I will let you all make your decision and your recommendation to the board. Thank you.
All right, thank you. All right. So do we have a motion for purposes of discussion?
I don't have a motion, but I still have a concern with emergency access, and I understand there isn't a want to kitten trail, so I was wondering if there was how, for the right away, can you speak on Bolton and how that's being preserved or accessed, or what are you doing? Because it doesn't seem like you're paving that, but there's a park along there. I just want to make sure in an event of an emergency, they can, and I'm sure that passive park, if there was a sidewalk there, a fire truck will drive right up it if it needs, but, you know, I still have that concern, so I was wondering if there was some sort of, what's happening with that Bolton right-of-way.
Sure. So Bolton, as you heard from the testimony, our neighbors, Bolton doesn't exist to our west, off-site. And to the east, Bolton doesn't exist. So what we're doing is preserving the right-of-way. We'll build portions of Bolton as needed for the project. It's not intended to be emergency access. It's just a road that we put in through the middle of our property so that the county in the future, when they have a build-out network, they'll have the ability to extend Bolton to Coyote if they'd like, because Coyote is a Vision Road as well. They can get Bolton to Hicks or Bolton to Little, both Vision Roads. So that frames out but it frames out the ultimate build-out network. Again, on emergency access, if you all want to recommend that, absolutely, we can accommodate it. We've had it in our plans, we'd accommodate it. Make that recommendation, debate it, talk about it between yourselves. If that's the motion with that condition, that's fine. Ultimately, I think it would be helpful to the Board of County Commissioners to get your thoughts on emergency access as a collective body. So we have two functional accesses, as you heard Mr. Vermillion say. The code requires at the number of units we're going to have, around 600 or 601, we have to have two functional accesses. Under that, you have to have emergency access, and functional access, one functional access and emergency access. But we're going to have two functional accesses, and we'll meet the code requirements. But I can tell you I did the same thing at Sackleson. It was the same conversation. It was like to have or not to have, and ultimately the board made the decision not to have. I don't know what will be decided here, so I'm fine either way.
I think I'm kind of with Liam on this. I think condition 22 says that there'll be no emergency or vehicular access. And then I know in the memo it says that fire had no comment, but we also heard from the fire department several months ago that they really don't look at it till site plan. It's not, it seemed like to me. So maybe we don't limit it completely, or, because you got the binding site plan, that's gonna show the park. But if fire determines they need access, I think we need to leave the door open for that, would be my thought.
And I think we had a lot of discussion last time talking about making sure if there is emergency access, cannot be converted to, as much legally as possible, not converted to full access. So, I would be open to have some sort of condition where it's, hey, it's up to fire, but in the event that they determine they want emergency access, that it cannot be converted or restrictive as possible.
We have a condition in Sackleson. I didn't bring it. read it. We did the same thing. We had to dedicate on the plat, dedicate ingress egress rights, and that one included emergency access. But you certainly could take the same Sackleson language that we put together with the county attorney's office, and they had like 3 different ways that we had to make sure that we couldn't convert by handling it on the plat, that we couldn't convert later to full access. So
And then
we
for-
certainly can handle that.
For Bolton, your east side, although I don't think it is a public road, goes to that Mattis Road.
To Mattis, right?
How is that being handled with that road? Because I think you said you were rebuilding that road, but not connecting.
The conditions say that we'll build Bolton as needed for the project, so depending on our ultimate layout, we may never get to the property lines. Both the west and the east would convey the right-of-way. Mattis Road is a county, on Pasco mapper, is a county-maintained road, but on private property. There's no right-of-way for Mattis Road. But ultimately, we also wrote a condition that ultimately, if we do end up constructing to our eastern property line, then there's a provision of how we barricade that and so forth. But we're open for ideas on Bolton, certainly, but that's how the conditions read.
I thought there was a pretty strong push by the residents not to have any vehicular access from Kitten Trail.
I agree. I'm not saying that there has to be emergency access. I was saying, I wish fire maybe made a comment. I do have a concern that there's only 2 accesses from Bolton. This stretches all the way, or from Denton, and it stretches all the way down to Kenton. And that's a long way, and there's houses in there, so I would be concerned for emergency access. Now, I'm not the emergency access guy, So I would defer to somebody else of making that determination at site plan review. So that's why I was asking on Bolton, if it goes to Mattis, can there be emergency access over there somehow, or, you know?
I think if at some point Mattis was improved to county standards, yes. The reason they're having to barricade the access to Mattis is because it's not improved. Mattis is not a standard roadway. That's why they're barricading the access to Mattis. It's not a standard roadway.
But we've done before, the county's done before that they still provide emergency access to a substandard road.
As long as the fire marshal says it's got enough compaction to carry emergency vehicles.
I don't know if anybody's evaluated Mattis for emergency access. Staff, does anybody know whether Mattis has been evaluated for emergency access?
It has not.
I mean, I don't know if anybody else has this other concern. Maybe there can be some sort of added condition that says the fire will review if it needs emergency access. I feel like there should be some sort of emergency access, but I understand the residents don't want it. I understand it, entirely up to the board, but I think somebody should look at it, and maybe fire review says, nope, not needed, all good. That's their review, that's there, but I think there should be maybe a called out condition that fire should specifically review if there needs to be emergency access. And maybe that emergency access option is to Kitten or to Mattis, and it gets reviewed at that time. And that it has a condition that except for Bolton, but a condition that it will never turn into a full, vehicle access, just like Sackleson.
Well, the fire department does review MPUDs. Did they comment on this?
Yeah.
Fire issued the comment, no comment.
Maybe they reviewed it and say no emergency access, but I don't know how much review fire does with MPUDs.
When they issued the comment, no comment, at that time, was there no access to Kitten? Because this plan has been through a few iterations.
My laptop has now died since it's 5:15. I'd like to use Gianna's as a loaner, and I can check that out for you.
Well, he's checking that out too. Condition 17 does say that the access points in the master plan are conceptual only. Permanent placement of each access point shall be determined at the time of review with the corresponding preliminary site plan. I'm not sure what PDP is.
Yeah, but there's a different condition dealing with access to Kitten.
Right, that's what I'm saying. And then 22 then says there's not going to be any access to Kitten. That's in the dedication of right-of-way section.
I don't know if I'm the only one with this concern. And again, I will defer to somebody else to make that decision who's more qualified to see if there's emergency access or not. I have no issue with that.
Well, perhaps you could, I'm just trying to think of what you could do today, is if you ultimately recommend approval, you could certainly ask that emergency access, an option of how that could be done, be presented to the board so they have an option. Is it Mattis? Is it Kitten? Could it be Mattis?
And maybe fire can.
And fire could weigh in.
An affirmative answer from fire that would be
Right,
able to comment.
right. So when evaluating the option of emergency access, so they would have an informed decision.
Yeah.
I mean,
They could have fire look at it.
You could move it forward with a recommendation that fire rescue relook at the.
Reviews and make a comment on if they need emergency access.
Yeah. that
And
they
if so,
actually
where? Yeah.
Really look at it, as opposed to just issuing a response with no comment. they specifically look at whether there needs to be an additional emergency access or not.
Yeah, I'm good with
And
that.
if so, whether Mattis would suffice.
It's a good idea.
I think that works.
Just not sure what Mattis gets you over the second access that they have. If one had an emergency, you would have to enter the project. Let's assume that the emergency happens down on the south end of the project, closer to the Kitten Trail side. The emergency vehicle would enter from Denton Avenue, drive all the way down to the south side of the project, and then have to drive all the way back to the north side of the project to get back out. And Denton does not go through, Mattis, I'm sorry, does not go through to Kitten, so you'd end up back in the same place. You may be a few hundred feet east or west of where you started, but at the end of the day, you're back to Denton. You went full circle and back to Denton.
I guess your point is unless the connections to Kitten is not gonna do any good.
And/or Bolton. Bolton is a possibility. Yes.
Yeah, I mean, Liam, I tend to
Bolton
agree
is
with
not
you. I mean,
extended.
whether it says it on the map or not, if emergency's there,
I-
fire's
fire's gonna
vehicle's
use
gonna
it.
use the Kitten trail access to Kitten. I mean, that's reality. I mean, I've seen them drive down the trails before. I've seen them drive down the Starkey Trail. I mean, so.
They'll just use the pedestrian
They
trail.
use a pedestrian trail. I mean, it's a 10-foot trail going to Kitten,
Yes,
correct?
that's correct, yes.
I mean,
Could be.
We certainly can take the idea, which is between now and the board, to have fire weigh in, fire emergency weigh in. Look at Mattis, look at that, and let them offer their professional opinion.
And if they're fine driving down the trail, that's fine too.
Yeah.
Right, right. Yeah.
Well, one of the biggest concerns I have is even if we wanted to deny this application, don't we have some legal issues there? Because this property was already identified and approved for land use Res 6.
Yes.
And they're making a lot of modifications to come down from those, you know, that type of designation from what you said, 1,400 units down to 600.
1462 to 832, 6 units per acre to 3.0, which, by the way, the surrounding land use is 3 units per acre.
You know, it would be no different than if we tried to take a land use away from an adjoining property owner that they already had. And, you know, if you had a 5-acre piece and you had the right to do certain things on that property according to the land use, you know, I think you'd have some challenges if you wanted to take away their property rights. And could put us in a very tenuous legal position. You know, that's why I was encouraging you to try to be as accommodating as you possibly could to the residents in that area, because, you know, we want to get the best, you want to make the best deal you can.
The best balance we
for
can.
the surrounding property owners.
The best balance.
And so, David, that's probably a question for you.
Well, I mean, it's a balancing act because, as you know, there's also comp plan provisions in case law saying that you're not entitled to the maximum of land use.
Right, and they're not taking the maximum.
Right, so, but, you know, I can't tell you that there's no grounds for a denial, but this is certainly not as easy to deny as if they were requesting a plan amendment.
Right.
There is a presumption that you should approve it if it's consistent with the comp plan.
So, I said last time, I didn't want to deny it, and I still don't want to deny it, because I recognize people have property rights. No different than anybody else who's come up to speak today. If they want to go and build something on their property, they have rights to do that too. So we recognize property, and there's a property rights element in the comp plan. We recognize property rights. To me, this case comes down to and this will be interesting, David, going into next year, what is compatibility? And Barbara, I'll apologize because I don't mean to be putting words in your mouth, but to the applicant, compatibility is I did an analysis and see I've determined, my analysis determines this is compatible because you voted over here this way and you voted over here that way. There may be some argument for that, some justification. But I also give some weight to some of the arguments made by the residents today that the mass, the scale of the projects that we're talking about is not the same as this mass, the scale of this project. Hudson Family Trails acreage is, and total unit count is not the same as what this project is. And I think one resident pointed out that at Hudson Family Trail, it affected 6 or 7 property owners, and I quickly pulled it up on the aerial, and that was true. I think I counted 7. There's more property owners that are affected by this property. Why I say to David, what'll be interesting next year is we have HB 399 that the governor signed, and we're gonna actually have to define what's compatible, and the law says we're also gonna have to define what mitigating measures can be implemented when things aren't compatible. So that's something we're all gonna have to figure out.
My
And,
understanding, the staff is supposedly working on comp plan and LDC provisions to implement that bill.
Well, and I'm sure there'll be a subject of great debate when they get to the
Yes.
planning commission. And the public needs to keep their eye on that ball, because that's, right now, what's compatible, I looked in the comp plan glossary, there's no definition of compatible in our comp plan glossary. So I know typically in law, if there's not something that's a defined term, then we look to what's the common meaning of that word. And this is interesting, because while we were talking today, I was researching this and looking this up. In a legal context, compatible generally means the capacity for 2 or more things, activities, or entities to coexist, function, or be held concurrently in harmony without causing material interference, conflict, or negative alteration. And the exact definition depends on the area of the law, and the first example given is land use and zoning. In zoning law, a compatible use means developments or activities can sit near each other in harmony. Well, I'm not quite sure what in harmony means, but to me, if there was harmony here, I wouldn't have a full house. And I think it's important for the applicant to continue to work with the neighbors to find some way to coexist in harmony. Clearly, there's not harmony right now. There's discontent, but I recognize both sides of this argument.
Can I add something? Your code actually defines compatibility.
Where? Because I
It's
looked.
it's 522.4A1, compatibility of uses. It actually exists. Your comp plan gets implemented by your code. You actually should read the code.
Oh, read it.
I would just,
I'm just
instead
telling
of
you,
reading.
there's nothing in the comp plan glossary.
Right, but that's because your code implements your comp plan, and you actually adopted development standards, 522.4A1. Read it, and I was like, I thought the same thing about compatibility. But it actually says it in the code.
Where's it
It
say?
says applicants must demonstrate through lot sizes, buffers between uses, or other information that the project as designed transitions appropriately to adjacent uses, or effectively shields adjacent uses in the absence of lot and use compatibility. Your code has said that if you buffer, you can achieve compatibility, even if you don't have lot compatibility.
Does the code define what is effectively shielded?
Yes, it does. It's in your land development code, what you've adopted for buffers, what the county has said in land development code between this use and this use, this is your required buffer. What I did was exceeded that 3-4 times. So I didn't take the basics here and say, it says or, and I can, what the other ones did, by the way, the ones I told you about, they just went with the code. What I did was I said, okay, I'm gonna achieve use compatibility, lot compatibility, and I'm gonna do the buffer. The other projects came in and read this and said, I'm just gonna have to, all I gotta do is comply with the code compliant buffer, and I'm compatible as a matter of your code.
Well, the only difference between that and the land development code is right now you don't have the zoning. That's what you're here asking
But
for.
but the land development code tells me if I'm zoned, what's compatible.
When and if you get the zoning, first you gotta
Well,
get it.
Well, we can stay ag to ag, and there's no buffer.
Well,
So,
okay.
but anyway, I don't want, it's not my job to argue with
think the
you.
applicant wants to develop
I just wanted to point out there's actually a code that's been implemented. Instead of,
After we get the zoning.
okay,
I
I'm gonna
just, to
sit
me-
down, leave you guys be.
To me, speaking for myself, we're compatible when maybe only 1 or 2 people have a complaint or a minor complaint, not when a room full of people have a complaint. And again, I don't want to deny the project. For me, and I'm not making a motion, I'll let somebody else go out on a limb here. I think a continuance is in order so that they can go work out their differences. And I asked the applicant, I don't know, the public probably doesn't get to see the ex-parte disclosures, but I did have a discussion with Barbara and her client. And I asked if they had any additional neighborhood meetings, and the answer is no. I personally think some additional neighborhood meetings and hopefully some ability to compromise on both sides can get the issue resolved. But I think we'll have harmony, compatibility and harmony when there's not a line of people that need to continue to come up here and tell us about how this is not compatible with their way of life. And I'm sorry, in my opinion, the fact that whatever builder you're dealing with doesn't want to buy 1-acre lots is a you problem, not a community problem. I think I'd probably be dialing and finding somebody that might want to do some larger lots, because I think that's going to be the answer out here, at least for me. We'll see what the other guys want to recommend and what the board does, but that's just where I'm at with it.
Well, Barbara, I think it's a borderline issue here, and how do you feel about a continuance?
4 years, 4 neighborhood meetings, 3 of them together, a long separation, a 4th one. We have continued and continued. We've struck the balance here. It's not the project that we had started with either. It's far from the project that this property owner started with to begin with. And that needs to be recognized. I mean, we're looking at it as a point in time today, but it's been 4 years. And the project that we started with, which was consistent with the comp plan, was a much different project than we bring you today.
Mr. Chair, I mean, obviously, we're here belaboring this, there's a lot of people here, this isn't an easy one. I mean, to me, it comes down to, like we've already said, I mean, the land use is in place. They're coming in asking for something below the land use, acknowledging the fact that there needs to be a change to zoning. I think over the 4 years, I think that they've worked tirelessly with the neighborhood. We have problems every project that comes to us, it seems like has, the adjacent property owner doesn't always want what's gonna be in their backyard. I think they've made a lot of accommodations. I think they made a lot of concessions, a lot of changes to their plan. I think they've gone above and beyond in what they're proposing here. They've shown there's compatibility, or the adjacent surrounding projects have been proven to be compatible with approvals given. So I just in the essence of getting something on the table, I move for approval.
I'll second
With-
that.
Let me, one second. I do need to, I want to add this condition for the rural disclosure condition to the conditions of approval with my motion.
And, well, I'm wondering if you can add that fire will take a second
And-
look.
And I will add that fire will take a second look at this before it goes to the board.
Okay.
For
so we have a
emergency
motion.
access.
Yes, for emergency access, correct.
A motion and a second. Is there any further discussion on the motion? If not, all in favor of the motion, signify by saying aye.
Aye.
Opposed, like sign.
Nay.
Motion carries. All right.
Gianna, what is the board date?
June 16th.
Yes, sir. Yeah, oh, yeah.
Do we have to adjourn planning commission?
We need to adjourn this meeting? Move to adjourn? Question?
Second.
You guys can start.
All in favor, say aye.
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 You just end up in a legal battle if we didn't approve it.
No, I understand.
I think you, I mean, my sentiments go with you,
Well,
but legally, I don't know. If it's, I don't know if we have a strong legal position.
It's my show now. You were saying though.
I'm getting out.
I have people come in my office all the time and scream, jump up and down and scream when you tell them what the rules are. Well, I'm gonna sue the county, and I just tell them, yeah, go over there to the county building, on the third floor, there's an entire floor full of attorneys that have nothing to do but respond to lawsuits from people like you, and you'll be broke long before you ever.
David has a lot to do.
No, that's why he's got that room full of attorneys to do all of this.
We retire outside council.
Well, whatever, yeah, nonetheless. Compatibility is when I don't know 20 people sitting out there.
Say that again.
I said, to me, compatibility is when I don't personally know 20 people sitting in the audience.
It's on the board.
would
How
think
many
so.
times have you said, somebody said, I bought here because somebody told me nobody else would ever build here again?
Chuck,
And they never
in
checked.
our office, we sit there and laugh all day long. People will research to death buying a car or a truck,
Yeah.
or even what food they're gonna buy at the grocery store. I have never seen so many people that go out and buy property, haven't got a clue
Right.
what they are buying. They don't, yeah, this looked like a beautiful piece of property, yeah, well, it floods 5 feet deep. Yeah, or
Yeah.
they don't understand that they go down to the city, and the city says that zone, well, that's land use res 6, you can do six dwelling units to the acre.
Yeah, on
And
how
then they come
easy
back
would it
and
be?
tell them, yeah, but 95% of your property is a jurisdictional wetland. Yeah, but they said I could build 577 units. Well,
Yeah.
It's like every zoning walk-in I've ever had. I thought I can do whatever I want. What do you mean I
They
can do
do.
it?
You look too serious.
I got two young guys that work,
I was ready to go.
two young guys that
Alrighty.
work in my office.
She had 2.5 hours, 3 hours to cook dinner. I wonder what she made.
I did, and dessert too.
All right.
I think we have to wait, the clerk's office has to reboot the computer. If we can wait,
Bossy.
sorry.
You know?
That was boss.
You know, Chris just sits there.
I know.
Oh, wow.
We had a Pasco K workshop, is the reason Pasco Elementary Middle, your mom's there, and I met her, she's the sweetest.
Yeah, she, my wife sent her to that. We're zoned for Pasco Middle. We're currently at San Ann.
Salmon.
Yeah. And Cambridge used to feed from San Ann to Pasco Middle.
Yes.
So I can put Cambridge and Pasco Elementary.
I'm sorry, what was?
The Cambridge program is at San Ann and then at Pasco Middle. They didn't have Cambridge and Pasco Elementary.
Great question. I don't know.
Yeah.
I don't know off the top of my head. That is a good question.
Yeah, they're gonna move that to,
Pasco K.
yeah, to move it.
Madam Clerk, are we on the record now?
Not yet.
Not yet.
Your mic's still might be on.
Apparently you're being live streamed. Not sure why the producer can't kill the mics, but.
Yeah, so that's our big question to figure out. We got one in kindergarten.
I can find out, I'll let you know.
That would be good.
Remember a long time ago when Liam brought us a cookie whenever we were in Dade City till 6 o'clock?
Yeah.
The staff's not what it used to be.
Denise used to get those muffins, the Florida cracker.
Yeah, that's not very thoughtful.
The good old days.
Yeah, and we gave you all morning to do it.
I know, I had,
Well, he's changed sides of the table.
Yeah, I know, well, I had said she made dessert, so. You think she was joking?
Problem is, that was at 5 o'clock, she already ate it.
I did. I went upstairs and ate everything.
Well, if we're gonna be a few minutes, I'll take a quick break.
always get a kick out of, your code says, and your code says. Yeah, but you wrote the code. It's always yours.
My mother-in-law always uses that your term when she's talking about my wife's father, your father.
Like when I said from out of your kids.
Yeah, that's right, your kids. See what your kids did?
Kids are crazy. My kids are all cool.
Yeah, that's right.
That was my next question. Just digital.
Okay, good. Yeah. I see our rules for.
Just got a text from River Ridge, said that backpacks are not allowed at school next week. Why do they have school then?
Right? We're not gonna do anything anyway, so just don't bring it
Jeez. Keep school closed for River Ridge for a day, because there was a fire, smoking on campus. So they actually extended the school day for the last 8 weeks by like 4 minutes a day. No, 6 minutes a day. 2 minutes in the beginning of the day, 4 minutes at the end of the day, or vice versa. Instead of starting at 7:10, they started at 7:06, and they went, instead of 1:30, they went to 1:32. To make up the number of minutes, we allocated hours.
For my
So one more minute every period.
It's like,
Is it really? I mean, come on.
not really effective.
From the
I don't read the letter, but not the intent.
Oy, oy, oy.
Maybe all the teachers signed a promise to talk faster.
Yeah, right.
Oh, no, did your dog really?
Daughter graduates 8th grade, graduation's Tuesday.
No problem.
She had her last end of course exam today.
Alright.
She had homework in 2 weeks.
Well, no, I'll wait. I shut it down again. Just give it a second chance.
Looking back, you never realize how easy it is in school.
Oh my God. I remind my sister that every day.
We got out at 2 o'clock.
We got out at 1:30.
You could get it at 2. What do we do all that time?
Did my eye roll?
I thought it was crazy.
Right, from my actual log.
Like, either as young as my kids are, like I said, worst day ever. So far, don't worry. We'll get there. This is not the shit.
So when I went outside, a couple of residents accosted me verbally and called me a landlord. Jeez. You know, that's uncalled for. So I explained to the residents that our job is to enforce and maintain compliance with comp plan that was like 2010. And the consistency obligations of the LPA were delivered.
Yeah.
That's all that matters, really.
But the elected officials. But attacking staff isn't.
They got Gianna in the
No.
back.
In the bathroom.
Apparently they're.
When there was that like
I
5
think
minute
we're-
recess?
Yeah, they did.
That's why I waited till the meeting started back up to go out.
Well, you should have told me that. I would have, somebody, I would have deputies out there. That's
Yeah,
ridiculous.
they can. That's, dude, costing somebody in the bathroom.
Mhm. That's why I waited.
Seriously?
I was like, I'm just
Yeah.
gonna wait.
Yeah. What did they tell her?
When I was in New Jersey, I was.
Nobody said anything to us.
She was like, it just wasn't cool. She was very
I didn't even think about it. I got halfway back there and
And I was driving in my car to a
Oh, yeah.
temporary
Yeah,
I always go upstairs.
I had to get past all that, I was in the bathroom.
I just get my hat down, like, I just gotta go.
And my car was, basically, my tires were punctured, and they destroyed my car, so the state compensated me, but I drove the state car. And at one time, I had to have a state police. You studied, you know what the Mount World cases were, you know, fair share of low moderate housing. And basically, we had a discriminatory exclusionary zone by the state. Well, sure it was.
It's a famous case.
Well, I wasn't involved in the court case,
Oh, yeah.
but in 1982, the Supreme Court for Planning Council to come up with a implementation plan for Mount World II. And I was on that committee, and then the role assigned certain assignment judges throughout the state to work with.
It's a historic,
It was historic.
Do you have any more of those jerkies?
You want some? Feel free. Is it spicy or not spicy? Pick one. The green is spicy. Welcome.
Anybody?
yeah, I'm good, thank you.
Spicy?
I'm good.
John? Soup? Is it food your new diet routine?
No, not hungry. I don't usually eat till late.
I started and then I was like, I gotta sit down.
I'm in the middle of the motorcycle, so I'm distracted. I'm not that outside.
How are you being measured as well? I guess we can. We're not talking about the stuff, how are you being spread? What can I say?
You know, I look at the
Smell
left.
it.
Well, no, I
Take notes?
no, I want to be standard and consistent.
Everybody's having dinner.
So I'm going to scan a couple.
This is why I bring these things. For meetings like this.
Boy.
Remember my dad's go-to was peanut butter.
What's that?
My dad's go-to was peanut butter.
Oh, me too.
He's keeping his drawer and pull it out when he starts to plug out.
Just spoon it out.
Who's that? Who's that great planning firm? I wish they would find. They wouldn't have the patience.
You're in a brave soul.
Well,
I know. Soul today.
Most of the cities they work for are Kool-Aid drinkers. I'm New Orleans.
Going for it anyways.
I'm drunk on New Orleans.
What do we say the other day?
It could be that. It could be that, I could just be drunk. I hadn't had a drink.
We're trying, just give it a couple more minutes.
The old, I was one.
I thought this would be the easiest chapter in the comp plan, but
You're like, all right,
it's
I'm
not
going
gonna
home.
happen.
I'm done.
Huh?
First.
I told you to
Say that out loud to somebody? Way to go.
Right?
This is the first day that I'm not fully pain free from this. Chronic pain is terrible. That's usually
At least I got a big chair.
but you don't need to use it.
I never noticed that chair was different.
I never noticed that sure was different.
I've
So,
never
you know?
looked at those. I can't afford it.
True.
Is in Dade City, it's the same chair?
It's the same chair.
Yeah, she said she didn't. Did it shut down?
too.
That way it laid out there, yeah.
Yeah, I'm a land rapist.
Huh?
And I was at Cox's outside, they told me a land rapist.
By who?
From the residents.
They called you that?
Yep. Well, the same ones I explained that,
It's already
we're bound by the comprehensive plan. That's our baseline. In terms of actual official.
Well, your job is no different than ours, it's just to make a recommendation.
Terrifying.
Nobody's got, if these things were absolutely black and white, we wouldn't be having public hearings. Right? If they're black and white,
You know,
that's why we're here.
And it's also not a yes or no, there's
Why, it's
alternate
fault.
plans
It's
and
all.
creating
Got it.
resolutions.
Chuck, it's your fault. Chuck.
I appreciate you, sir.
Good.
You're right.
I was gonna say.
Try to create harmony.
That's right. Big time at ROI. That's why we were looking for cookies. Oh, it isn't?
Can you drip from that side?
Oh.
And then, that was 1976, so
We think it's from the software.
Oh, just a
Oh, really?
We're recording with
Recording with that, okay.
old school, but it just, it's over. As
Old
long as
school's
everyone
a
projects their
megaphone.
voices, it'll be good.
So here's my question. Honestly, because I'm curious. Are we still gonna be on YouTube though?
Yes.
So you'll still have that recording?
Everyone's here.
You're just not picking up our mics to your system.
We have
Teams
teams
Got it.
still. Yeah, we have teams and.
15.
Okay, good.
Are you recording the teams?
Threatened me to have,
Okay, so you'll.
I had to have a sheriff's deputy park outside my office for.
Yeah, so if you missed something, you can go back to YouTube and.
Yeah, pretty much.
most of the residents will be.
Where are you on YouTube?
I said, we're all doing our job.
Pasco County YouTube?
Well,
You just type in YouTube
there's
Pasco
zoning,
County, we'll pop
zoning is
up.
an interesting thing. Prior to
You're usually-
December 31st, 1975, we didn't have zoning, right? You could have built whatever you want.
Yeah.
So you could have had 100 acres, somebody could have built 10,000 houses.
All my kids like to watch
Nothing you could have done.
Whatever you want, what we want.
I used to, when I used to present, I would have somebody like just be like, hey, what are you doing?
Well, nobody
And I
knew
would,
what zoning
talk,
was.
And I would send them a link. So we know what video.
So I was in,
How old were you, like?
so in 1975, I would have been 9 years old.
I guess it depends.
They used to have the, was everybody ready?
Yeah. Thank you.
You may begin.
Okay, thank you. Thank you, Mr. Chair. Good afternoon, commissioners or planning commission members. Hyatt Mazzilli Planning and Development Economic Growth. I know it's been a full afternoon, actually a full day already, so thank you for sticking around so we can continue our progress through the Pasco 2050 Comprehensive Plan chapters. All right, back to my old trusty slide. So this morning we wrapped up the public facilities element, the second half of chapter 10. And as a quick reminder, the plan includes 11 chapters and we've already covered chapters 3 through 10. And that brings us to our next stop on the Pasco 2050 tour, and that's Pasco Invest chapter 11. So let's take a quick look at Pasco Invest and all the updates that we had done so far. So what is Pasco Invest? Pasco Invest is the new name for our capital improvement element. This chapter is a mandatory element of the comprehensive plan per chapter 163 of the Florida statutes, and it provides a unified framework for planning, prioritizing, and funding public facilities and infrastructure across the county. And that's done by identifying capital needs to meet adopted level of service standards, prioritizing which improvements are funded, and also linking land development decisions to available infrastructure.
So what has changed in this update? First, like we always do with all the chapters of Pasco 2050, we have reorganized and streamlined the structure of the goals, objectives, and policies. The chapter now includes 1 goal, 5 objectives, and 50 policies, 4 of which are brand new. We have also made several key improvements. We moved relevant policies from the administrative element into invests. We also removed outdated and redundant policies, and the old capital improvement project schedules have also been deleted from this chapter. All the level of service standards policies formerly housed in other elements, including the administrative element, recreation open space element, transportation element, and public facilities element, as well as the public school facilities element, are now consolidated within invest to make sure that we have convenient access and also consistency. So overall, these changes make the chapter more user-friendly, up-to-date, and better aligned with both state requirements and our county goals. This slide shows the proposed 4 new policies. These policies are proposed to to be added to the comp plan or to this chapter to strengthen how we manage growth and infrastructure funding in the county. So first, policy Invest 1112 and policy Invest 1113. Both of these policies ensure that our county continues to implement and regularly update impact fees for both fire combat and rescue and the library services. This means that as new development occurs, it helps pay for the additional fire stations, emergency equipment, and library facilities needed to serve our growing community. The second policy that we have added is Invest 1.2.8. So this new policy streamlines how we update our capital improvement schedules. Instead of embedding the entire 5-year schedule directly into the chapter, which would require a comprehensive plan amendment every single year, the schedules get updated. We are now incorporating the schedule by reference. This policy allows us to update the data and analysis document where the schedules now reside. It's important to note that the capital improvements schedule currently in the comp plan have not been updated since 2010. So this policy is a significant step towards ensuring that we are consistent, or the comp plan is consistent with the annually updated CIP schedule or the capital improvement schedule. The third policy that, or the fourth policy that we have added is policy Invest 1.3.10. This new policy was developed in response to state requirements for local government to study and plan for septic to sewer conversions. While this requirement is for the feasibility studies, this policy is already addressed in the Pasco Serves. It is here to ensure that the county develops a funding plan which considers all the funding sources such as grants, utility fee, state and federal programs, and adjustment to any local fee structure. So that way we're ready to move forward with these important projects that we have identified in the feasibility study. And next slide pretty much just shows the policies that we have relocated from other chapters to this chapter. I'm not gonna go through each and every one of them, but I summarized them all in this table just to pretty much shows you what the policy number is and where it came from. And I did that, Mr. Moody, with you in mind, because you had asked me when we discussed Pasco Serves where those policies were gonna go. So this is to pretty much showcase where those policies have moved to in this element or in this chapter. I can open the floor for you, gentlemen, to discuss any policy that you would like a little bit more explanation on or more discussions.
Yeah, I just have a question. So, I guess I'm curious. So for roads, parks, water, sewer, solid waste.
Yep.
You have the level of service standards that you put in here,
Mm-hmm.
is fine, in schools.
Okay.
For fire, when you added fire, rescue, and libraries, you didn't put a level of service standard in. So what was the thought process there?
So we do not have adopted level of service standards for fire and libraries. The thought process of adding those two policies into this chapter is pretty much just to ensure we have impact fees LOS, but we just want to make sure that we're continuing with the implementation and updating of those impact fees. But currently, there are no adopted level of service standards for fire
Well,
and libraries.
The problem is the policies you've added refer to levels of service.
For impact fees.
So by levels of service, you mean the impact fee levels of service?
Correct, yes.
Because obviously you don't mean the comp plan levels of service because.
No,
because
no, we do
there are
not.
none in here.
Page 9. Page 9, yes. Yep. We discussed these policies with fire and libraries, and they pretty much were the ones that showed interest in having these policies in the comp plan.
I don't have a problem with them being in there, I just don't know, since you didn't add any levels of service
Right.
to the comp plan, I don't know what the reference to needed to maintain levels of service is referring to, since there's no levels of service.
Level of service for impact
There's
fees.
no levels, like all the other infrastructures have a level of service in the comp plan. So if you ask me what the levels of service for parks, schools, water and sewer and drainage and everything else, I could point to something.
Correct.
But for the two you added for fire and libraries, there's a reference to levels of service, but I would have no idea what that is. Because there's no corresponding,
Level of service standards
there was
for
nothing
those.
added to the comp plan. So you would either need to add a level of service to the comp plan for those, or you need to say what level of service you're referring to. Is the level of service in the impact fee study?
Correct, yes. That's exactly what it's referring to.
Well, then it needs to say that.
Okay.
In the most recent impact fee study?
I guess, if that's what the reference was supposed to. I'm assuming somebody intentionally did not want to put it in the comp plan, I guess, I don't know, I wasn't part of these conversations, but if somebody intentionally did not want to put them in the comp plan, then you need to say what level of service you're talking about.
So the sentence would read for both, well, it would say to maintain levels of service
As outlined.
as outlined in the most recent impact fee study and support future growth.
Or as identified.
Yeah, I mean, the only complicating factor, is my understanding, is that the most recent impact fee study for libraries was never adopted.
Well, and then does that mean that whoever's
So,
doing the study can just?
so I'm not
define whatever
sure
level of
that's
service
accurate
is?
for libraries.
Yeah.
It is for fire.
Right.
'Cause that fee, that was actually adopted. I just don't know if that's,
We don't have to say.
To
we
be
don't-
adopted in the most recent, in an impact fee study for libraries?
But do we have to say adopted?
I guess you
The
see
mo-
in the most recently adopted impact fee study, I guess, if it said that.
Okay.
Why can't you just define a level of service?
Well,
I mean, we
that would
need
be
to
the
do
other thing, is
impact
you could
fee.
just put the adopted level of service in the comp plan. I mean, it is a little odd to me that you have the adopted level of service for everything else in the comp plan, but you chose not to put.
What seems a bit bothersome is if you want to say it's the level of service in the most recent adopted impact fee study, well, that means every time I do an impact fee study, I can just decide, change whatever level of service I want for, to be convenient to justify the impact fee I wish to collect.
Well, that was one rationale in internal discussions, is providing some kind of flexibility so that if a level of service needed to be adjusted, you didn't have to do a whole comprehensive plan amendment to send it to Tallahassee for their approval.
Yeah, but for all the other infrastructure facilities, they're embedded in the comp plan.
But I think those other ones are state mandated, whereas a
Correct.
library and a fire are not state mandated.
They're not.
I don't, look, I've not been part of all these conversations. All I'm saying is that you can't reference a level of service and then not say what it, you either need to put that level of service in the comp plan or be more specific as to what you mean.
I guess one of the questions I have is, what's the problem? You want to define a level of service for fire. And hopefully, we don't want to decrease that level of service, we only want to increase that level of service. How long does it take us to do a comp plan amendment to increase a level of service for fire and send it off to the state? I mean, how burdensome is that? We come here every 2 weeks to do comp plan amendments.
The comprehensive plan amendment process, in this case, would be a text amendment, which would require 3 public hearings, the preparation of the necessary data and analysis for the change you're going to make, so there's some kind of study is going to take place, the public hearing at the LPA, a transmittal hearing by the at the Board of County Commissioners, a 30-day built-in or more waiting period for the state to review, then another adoption hearing by the Board of County Commissioners, and then a 40-plus day effective date time period associated with it. So it drags out, it could get 6 months and more.
To drive faster.
Two and a half of those months are just state review. To which I would also say that, you know, the pendulum swings. Back in the day, you had a state review that was very involved. Then the state review wasn't as involved. And now, I'm not saying that they're not involved, but neither am I saying that they are involved. They're producing more comments than the DEO days, let's put it that way. And the other thing that we talked about internally was, you know, what would happen if you had another Senate Bill 180 scenario, creating legislation that's more burdensome and restrictive, and if you're behind the ball on, say, parks, which historically the county was behind the ball on the park impact fees, you try to increase it, you could run into challenges.
To be clear, we still have Senate Bill 180. It hasn't gone away.
Right, true, yes. I'm thinking about the future, but yes. So that's where, for fire rescue and for libraries, because they're not state mandated to be in the comprehensive plan, the idea was to potentially give the Board of County Commissioners a little bit more flexibility on local home rule type things.
Seems reasonable.
I'll defer to whatever you all decide. My only point is that you can't just leave that.
We can
You need some reference
specify,
as to what
yes.
level of service standard you're talking about, if it's not gonna be in the comp plan.
Yeah, we can specify it. I think the language where we've left it now says something to the effect of to maintain levels of service as identified in the most recently adopted impact fee study and support future growth.
Then my other question is, there's a couple places, so it's very clear that the roadway levels of service are not concurrency standards. And it's very clear to me that the school levels of service are concurrency standards. But for everything else, they're not really labeled. So I don't,
labeled as
As-
concurrency
I'm
or
sure,
non.
Do we use them for concurrency or not? So do we need, like, is there somewhere that, or is that, do we just do that through the land development code? Like, how do I know? I guess where I'm going with this is, we decided for roads and schools to specifically label them as non-concurrency and concurrency.
Mm-hmm.
Is there a reason we didn't do that with everything else? Like, to make it clear that it is or is not a concurrency standard?
No, there was no reason.
Because I think my understanding is that some of these are in fact like drainage, solid waste, wastewater, potable water, that some of these are in fact concurrency standards. If that's true, is there any harm to actually labeling them as concurrency standards like we did for schools?
There is,
I don't think so.
yeah, there's no harm in doing that. It's,
I mean, you're right, they're being planned and discussed as they're proposing the project, so
Mhm.
concurrent in that sense.
I just, and now that we're adding fire and libraries, I'm just saying, which I'm assuming those are not gonna be concurrency standards, so I'm just saying, we should be crystal clear as to what, if we're putting a level of service standard in the comp plan, I think we should be crystal clear as to which ones are concurrency standards and which ones are not.
okay.
So the water infrastructure and the wastewater infrastructure, all that would be concurrency.
Same thing with drainage.
Well, I think the land development code is clear. I mean, you can look in the land development code, but I believe, I'm pretty sure parks, drainage, water, sewer. Look at the land development code. I'm pretty sure parks, drainage, water, sewer, and solid waste are all concurrency public facilities, but you can look at the land development code to confirm. But it's all the ones that are required by state law, which I believe are all the ones I just said.
Infrastructure, concurrency. Okay,
We do all the ones that are required by state law.
yeah.
Then
The only optional one that we do, I guess, is schools.
What, it's, yeah. It's not necessarily optional, but
So I just prefer that you be crystal clear that which ones are concurrency standards and which ones are not.
okay, sure. We'll add that.
Looking at the standards for potable water and wastewater, wastewater's a little bit better because it talks about equivalent residential units within Pasco County, but I think that's a bit, it should be residential units within the utility service area.
What page are you on, sir?
It's 114, 116, so it's page 6 of the red line, top of the page. Talking about capacity of both potable water and wastewater, so it should be per day per equivalent residential unit within the utility service area. I think is probably what we need to add to both of those.
Okay.
And I'm not sure why on 116 it's each new residential equivalent, or each new equivalent residential unit. I'm not sure why the word new's there. Should probably just be for each.
Yeah, I mean, that was reviewed by wastewater staff and they added new, but we can mention, like right here, 116. The word new. Okay, those are noted, Mr. Mons,
118, I've got a couple questions.
of course.
Can somebody tell me where the Pasco County Stormwater Management Practices Manual lives today?
Well, I've been here a long time, and I've never ever seen one.
about 10 years ago, there was discussions about revisions or tweaking that, and that died. And I don't know that I've heard that it came back.
And right now, the stormwater rules in the land development code say that our rules are the same rules in effect at Swift Mud in December, whatever, 2011. That's 16 years ago, 15 years ago, and by the way, the rules had a massive change on December 28th of last year, so.
No, nobody's online. I don't know if she's available.
Is it on their website?
I don't think it exists, Terry. There was not a, I've never seen.
Terry, I've practiced here a long
Yeah.
time. I have never seen a stormwater manual in this county.
Probably wasn't a fair question. Probably should have worded it, I apologize.
Was that, it was
I
a
don't
trick?
deal in stormwater, so.
Yeah, was that a trick question,
That was
Mr. Girardi?
Yeah,
That's all.
At 3 o'clock, that would have been a
Well,
word difference.
I think,
If it doesn't exist, then we could just simply strike it from
Really take away his charm.
the policy.
Yeah.
Hey, see what happens when you give them a chance?
I mean, I think it's a whole separate issue, but there is a lot of duplicate review when it comes to stormwater. Water Management District
Yeah,
enforces the DEP rules.
Mm-hmm.
Is this section required by the state law?
The,
Drainage standards?
You do have, drainage is one, a required concurrency facility.
yes.
But the reference to that manual is not required by state law. But you
Especially
need
if
to
it
have
doesn't
a
exist.
drainage, you need to have a level of service standard for drainage. But it could just be a reference to Swift Mud standards.
I mean, I'm okay if you just strike the stormwater practices manual.
Well, I think that would be wise, because, one, to Jamie's point, we already have a state agency that's charged with, managing stormwater. You've got to get that permit. For whatever reason, our county has not been able to update its rules or keep a staff that's actually capable of doing the analysis required to make sure those rules are complied with. Why don't we just defer that to the state and save our local taxpayers the money and time? There's a duplication of services that's unnecessary, and if your local rule is going to be, if you look at the stormwater rules, and our land development code says, our stormwater rules are the rules in effect at Swift Mud on whatever, December 2011. Well, why do we need to have rules? We're using their rules and they do it, why do we need to have them? Doesn't make any sense.
Okay with that, Terry?
I think making that decision is not my pay grade.
I just moved
I
you up a
understand the
line.
point.
Well, they're saying two different things. Mr. Girardi's just suggesting striking the reference to the stormwater management
Well, I
practices.
agree with him, because there isn't one.
But-
Never has been.
Mr. Moody's suggesting also striking the reference to the land development code, which is a bigger request.
Because it's unnecessary.
But that would effectively require us to repeal the land development code too.
No, you just repeal that section of the land development.
Repeal that section of the land development code.
That's kind of what he's after.
Well, I mean, if it.
That's the
continue-
part that's above Terry's pay grade. I don't think striking the reference to the manual is above Terry's pay grade if it doesn't
No.
exist.
No,
Can't give him a promotion.
I mean, if the land development code continues to be referenced here, but the code provisions are updated to point to the Swift Mud or whoever,
I
regulation.
could be fine with that too, but we gotta get on with it. We're
Sure.
talking about 15 years right now. We're
Yeah.
15 years behind.
Well, I mean, there will be, following the comprehensive plan update, as part of the county strategic plan, land development code update, to which the tables, the change tables that you see here, that you've been getting at the workshops, are not the end of the road. You'll notice that on the far right end of the table, there's land development code section updates. So with all the changes that are happening in the comprehensive plan, we're gonna go through and identify the code sections following as an exercise, and then we're gonna be going to the constituent departments and telling them, hey, you guys gotta update your parts of the land development code here. So that's gonna be a big question that probably requires a bit more higher level discussion before it filters down into department adjustments to the land development code. But I think my recommendation for this policy is keep the reference to the land development code. And to the extent that the land development code then is updated to point in the right direction, I think that's what you would want to achieve during the land development code update following this comprehensive plan update.
Well, I would argue you should strike the reference to the manual anyway, because even if there was a manual, that's something that's probably be addressed in the land development code, not the comp plan.
Okay.
Okay. The next sentence. All new, and then in parentheses, it's the word to include is stricken. And retrofit and redevelopment, buildings, roads, and sites. What is that saying? Is that all new development including, but that word's struck? Or is that saying that new is defined as retrofit and redevelopment? But what about all brand new development? It's just confusing to me.
Oh, I see what you're saying.
Is it suggesting that the buildings and the roads and the sites that come out of retrofits and redevelopment are considered new?
But so then table invest 2 doesn't cover new development?
It covers all buildings. I see the confusion though.
It is confusing.
Yeah.
Or
New-
maybe new
new
comma
retrofit.
retrofit and redevelopment, I don't know.
Well, if it's new development, retrofit, and redevelopment, then isn't that all development?
Yeah, right.
Doesn't it cover it all?
All new.
That covers everything.
All new buildings, including. Yeah, we should not
Yeah, I
have,
mean,
Say all
you have a point. It should just say all new buildings, roads, and sites.
Right, whether it's a retrofitted or redeveloped.
Well, and why, but to Mr. Moody's point, why isn't it just saying all development? Like, what is it not covering?
All buildings, roads, and
Yeah, I
sites?
guess it's grandfathering all the existing buildings, roads, and sites.
Right,
But at what point does new begin? I guess,
Well,
with the comp plan.
that's a debate, because without getting into too much specifics, and David Engel is involved in this, but we're gonna have to fix what the definition of development is in our land development code. Because right now it's being interpreted in ways that it was never intended.
delete new and then delete also retrofit. So everything, it doesn't matter.
I think that, I believe I'm hearing from the LPA here that the sentence should read, all buildings, roads, and sites shall meet the design criteria outlined in table of S to clean up the sentence.
Well, I want to hold on.
Yeah, because I don't think we're saying that.
The problem, no, because.
Existing needs to be brought to.
Correct, because the problem that I have is in that our definition of development, a change of use of that building constitutes development. Okay, so if I go in and I take a building and I change it from a retail store into a restaurant, by that, then you trigger a stormwater review, that's not necessary. If I understood if I expanded the building or expanded the parking, but if I just simply changed the use.
Yeah, you don't wanna do that.
Right, and that's why I said we're working on that, that needs to get fixed in our
What if it
code.
said all new development or redevelopment as defined in the land development code?
Well, right now, that would include changing the use of the building.
But we could change that in the land development code.
Well, yeah, just as I'm suggesting we should change the stormwater regulations that are 15 years out of date.
What I'm saying is that gives you the flexibility to change the definition of redevelopment in the land development code.
Right.
Yep.
So is that to say all new development and redevelopment of buildings, roads, and sites?
No, all development is defined by the land development code. So then that gives the opportunity, in the land development code, we can decide what is and what is not development.
Right.
So that means,
I think we'd read all development, and you could put in parentheses, as defined in the land development code, close parentheses. I guess, do you wanna leave, you wanna say of buildings, roads, and sites? Do you wanna leave that in? Isn't that
Well,
it?
no, actually, I think that you're first, just all development as defined in the land development code.
Just done.
shall meet the
Okay.
criteria.
All right, then we just say that, all development as defined in the land development.
Right, because then he defines different standards for buildings, roads.
Right, true, yeah, okay,
Below.
right, yeah, you're right.
As defined. Shall meet.
The criteria in the table?
Yeah, so
Okay.
all this basically is taken out.
Okay.
Okay, then my next question goes to the table itself. I'm assuming these standards all came from the existing comp plan?
Yes.
Um,
Existing comp plan and what's in the LDC right now?
And maintained by the constituent departments that reviewed it.
Yes.
I guess they're in place, we're not changing anything, but I have trouble following the wording. You know, the example I'll give you, the first one says emergency shelters shall be designed to accommodate. Does it mean they can handle it? I mean, it can come in the doors and go out the doors? Is there not a standard for emergency shelters built above, just like there is for habitable structures? We're supposed to be 1 foot above 100-year flood elevation? I've never seen it defined as like a level of service where they can accommodate it. I mean, usually it's to a certain.
Yeah, what does that
elevation.
mean? I
don't know
agree. What does that mean? Accommodate a minimum 100-year storm event in 24-hour peak duration.
To deal with it. I don't know.
Well, no, it should say something, Terry, I think what the intent is that it should say something to the effect of that the emergency shelters shall be located at such an elevation such that they will not flood during a 100-year storm event with 24-hour peak duration.
Yeah, I mean, I think when they look for, like an EOC or something like that, I mean, there are certain standards that they look for, and certain properties, I think, are ruled out when they're looking for those sites.
Yes, that's correct.
So I just think that just needs to be better defined.
I'm just looking at the second one, all habitable structures shall be designed to accommodate a minimum 100-year storm event, 24-hour duration. Okay, well, does that mean the building won't implode during that
Yeah.
event, or it won't get wet?
I mean, it says finished floor elevation shall be 1 foot above the 100-year elevation, but,
Well, and then there's, you have two terms in the same box, 100-year storm, 24-hour duration, and 100-year flood elevation are not necessarily the same thing. And this is exactly why we should get rid of doing stormwater in the county, because it takes a certain level of expertise, which is what the state agency has.
Should these standards live in the land development code anyway?
Sorry?
Should these standards live in the land development code anyway, or should they be here in the comp plan?
Well, I think here you're trying to define what the minimum level of service
Okay.
is.
It sounds like we have to define what accommodate is the meaning in each of these
I mean,
statements.
I think this whole level of service section needs to be looked at. I'm not suggesting a material change to it, but, I mean, I think, I would guess, and I don't know exactly the dates of the history, but I know there's also, I mean, there is other closed basin criteria, basins of special concern criteria. There's other things, and everything in here is lumped. Are those really all the same for every, I mean, you start getting into the road level service, starts talking about evacuation routes, arterials, neighborhood and collector roads. It gives a less than or equal to 6 inches of depth on the outside edge of pavement. That starts to get pretty specific.
Yeah, and I don't understand the one for sites. The standard says flooding refers to standing water in agricultural land developed open or green space yards and parking lots and undeveloped lands designated for future development. This does not include areas incorporated into the stormwater basin master plan as flowways, floodplains, flood storage areas. Okay, well, what's the standard? That just defined what flooding was.
Is it really? We probably should mention that.
That's a good point. That's not a standard.
So we're gonna check the land development code really quick on,
It's 15 years out of date.
we're gonna check the land development code, see what it says.
The rules
We're gonna codify
15
that.
years out of date.
What's ponding on a roadway? So it should be less than 6 inches to make it passable. What's ponding? So there's no ponding.
So, okay.
I mean, there,
Can we come back and continue this workshop?
When, in the morning, you mean?
No, next month?
Yeah.
Because this is pretty much the.
We would recommend, if we're going to, if there's a request for continuance, we would not recommend the June 11 because it's a pretty heavy meeting so far. Probably looking at the July 9 for invests,
Okay.
Okay.
if that's at the,
Yeah.
if that's at the
Right,
pleasure of the
motion.
board.
We're not actually in a hearing, but yeah, so
Let's
moved.
make a motion anyway. Feel emotional.
I'll second the non-motion motion.
Okay. All right, all in favor? Then you can't say you didn't know about it.
Aye.
Aye.
All right, thank you.
All right, thanks, you guys and gals.
That was about the third, I was about to start my third.
I know, I'm.
Okay.
it's getting
Great, can we have a
concerned.
motion to adjourn now that we're continued? Their computers are dead.
You're more than welcome to take.
All right, I'll believe myself.
You're safe. You're safe.
Is Mr. Ponless recovering from the CNU last week?
Oh, boy.
He was in bed all,
Oh, he's not well?
he was, yeah, he was, stomach.
What'd you give him, David?
On airplanes.
What?
Yes, we're Pontless, so as they said he's sick, I said, what'd you give him, David?
He's not gonna get paid for today.
Yeah. I was supposed to start my vacation 2 hours ago.
I think we're done. We have enough technology issues. Thank you. I appreciate that. I'm gonna tell him tomorrow morning.
Everybody have a good Memorial Day weekend.